Hey guys, what's going on? So this is the continued testimony in Massachusetts versus Christine Ricci. Um, there was an issue with the audio the last few days. Apparently, uh, whoever's streaming, whether it's Long Crime Court TV, I'm not sure, but they were picking up the whisperings of the prosecution, discussing their strategy and all that. So the judge this morning said, if you can't fix it, I'm turning the cameras off. So she did, and apparently in the last few hours they've figured out how to make sure that they're not recording those little private conversations. So we're just going to jump in here. I believe this is Michael Jr. That's where it's starting this morning. Oh yeah, and because they switched up the volume, it's really hard to hear. So you have to like turn you may have to turn your volume all the way up. I'm not going to talk. Obviously, I don't talk very much on these things anyway, so you don't have to worry about me coming in and being super loud. But it's real hard to hear now.
Cross-examination.
Good morning, sir. Good morning. I wanted to start and just talk a little bit about your parents' relationship before October of 2018.
Sure.
You mentioned on direct examination that their relationship, you described it as good.
Yes.
They did things together.
Yes.
They were affectionate.
Yes.
They expressed love for one another.
They did.
You never expected in any regard that they had problems in their relationship based on what you saw.
Based on what I saw, no.
Right. They certainly never started sleeping in separate bedrooms or doing anything like that before 2018.
Not that I noticed, no.
Okay. And they seem to have an open relationship where they talked about things.
I don't know what they talked about,
But in your presence, they would talk about things.
what do you mean?
Well, they seem to have open communications about their feelings and things like that before 2018 also.
Sure, if it would be an affectionate, like I love you to each other, yeah. But I don't know.
Right.
The details between each other, I wasn't there
Right.
for that, so yeah.
You guys ate dinner together.
Yes.
By the way, when dinner was prepared, who would be primarily the preparer of dinners? It was your father, wasn't it?
My dad, yes.
Yeah. And he would be the one to use the cooking knives, right?
Sure, yeah.
And in fact, the cooking knives were a gift, weren't they, from Christine to your father?
I don't know.
You don't know. Okay. They were thought of as his kitchen knives, weren't they, or the cooking knives?
They were the cooking knives.
Okay. All right. Your relationship with your father was extremely close.
He was my hero.
He was a firefighter. You, for a while, wanted to be a firefighter. Is that right?
Yes.
He was in the military. You wanted to be in the military.
Yes.
Essentially, he was sort of a role model, wasn't he?
He was.
And when you think as highly of someone as you think about your father, it must be very hard to hear people say things that are not flattering about them, correct?
When I was younger, yes.
Yeah.
It was tough to hear, yeah.
And even when you were just getting out of high school in like 2018, to hear him talk about himself badly was also a painful experience since you loved him and he was such a role model too.
Yes, it was tough, yeah.
Right. So when he came home in October of 2018 and sat everybody down and told you that he was an alcoholic, that must have been a pretty big blow to you, right?
It wasn't more of a blow, it was more of a confusion.
Right. And when he told you after that, you immediately went and he told you about the affair. That must have been extremely difficult for you to hear that.
That was a little bit tough, yeah.
Yeah. Because you didn't like holding the thought that your father had done something like this, given the way you thought about him.
Well, we put our heroes on high pedestals as
Right.
kids, so it was tough to hear, yeah.
Right. And it was clear during the conversation about the alcoholism, wasn't it? That was done with both you and Sophia present.
Me and her were next to each other on the couch.
Okay. And then he had the private conversation with you alone in the car.
Yes.
Was it clear to you during the conversation in the car that he was suggesting that his alcoholism played a role or was part of the story of the affair?
All he told me was that he saw another woman.
Okay. Did he tell you about, but it was clear at that point that he was saying that he was an alcoholic.
He didn't say that in the car with me. We talked about the alcoholism when we sat down. All he said was that I saw someone else in the car. He didn't say, I saw someone else because I was drinking. That wasn't told to me.
He had just told you that he was an alcoholic, and now he was telling you about another woman. Do I have that correct? About less than an hour later?
Yes.
When he told you about the other woman, did he say that whole thing that I said earlier about alcoholism? I was just saying that.
No.
He didn't mention anything about that when you were alone.
Yeah. No, he didn't say that.
He would have known that you understood his words earlier to mean that he was saying that he was an alcoholic, correct?
If he was assuming that to me, then sure. But
Well, he said it to you, right?
all he said was that I saw another woman. I mean, that's.
But in the group meeting, he said, "I'm an alcoholic,"
Yeah.
and he never contradicted it when you were alone with him.
No.
Okay. After that conversation, you said that your father's sobriety date was 11/11.
I believe so.
Okay. So, even though he said he was an alcoholic in October of 2018, it may have taken him some time to start doing AA. Is that your understanding?
It seemed pretty immediate.
Pretty immediate. Okay.
Yeah.
So he starts doing AA immediately, right?
It seemed pretty quick.
And he started going to meetings almost daily, right? Multiple times a week.
I didn't pay attention how quickly he went, but
Okay. You know that eventually he started going almost daily, right?
sure. Yeah.
And you're aware that he got a sponsor, correct?
He did, yeah.
Yeah. And you're aware that he was working the steps of AA, correct?
Yes.
And you're aware also that he would do commitments, correct? Where he would go talk to other AA groups.
I didn't know about that. No,
Okay.
I didn't know he'd talked to other groups.
Okay. Did you know that he went to a men's group?
I don't know
You
how
didn't
AA
know, right?
works, so I don't really know.
Okay. So you never knew all the details of all the AA that he did. You just knew about his regular group meeting.
Yeah.
Okay. So he didn't talk to you about the men's group or doing commitments. Do I have that right?
Yeah, no, that's very personal to him. So,
Okay. So you just don't know about that.
yeah, I just wasn't
Okay.
there for it.
It was clear to you, though, after that conversation in the car in the Shaw's parking lot where he says, "I was seeing another woman," that his plan is that he's going to stay and he's going to be working on the marriage. That was your understanding, right?
That was my understanding, yeah.
And part of that work meant that he was going to start going to counseling.
Sure.
Did he tell you about that in the car? Or did you just find out that later?
That
when you
was
saw?
later on known information to me.
Okay. But your understanding was that he was there and he was going to do whatever work was necessary to fix the relationship.
Yes.
And did he communicate that to you in the car?
Not in the car, no.
Okay. But within about 2 months, you start seeing some real effort on the part of your father to get sober, to start going to counseling and do these things. And you forgive your father, don't you?
I do.
Within a couple months.
Well, I was supportive of my father.
Of course. And that's understandable.
Yeah.
But you had if you had any feelings about the fact that he had the affair, within about 2 months, seeing his efforts, you reconciled yourself to forgiving your father.
I didn't condone him for what he did, but I let him know that I'm not going to go anywhere and vilify him for doing it.
Right. And at that point, when you decide maybe about 2 months after that conversation, so we're talking end of 2018,
Okay, yeah.
does that make sense time-wise?
Yes.
More or less? Because you're out of the house by June 6, 2019, right? So end of 2018, you're seeing this effort by your father. You're feeling feelings of, forgiveness. You want things to go back to the way they were, don't you? The way they were before the conversation.
In a way, yeah.
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 The fact that the affair kept being brought up was keeping you from being able to go back to the way things were before the affair.
Well, I'm not one to look to go back to the past. I mean, it'd be nice to not have that be brought up every single day.
Right. And you felt like your mother was bringing it up every day, and you really started to have a feeling of resentment towards your mother because she kept bringing it up after you had decided that you wanted to kind of go back to the way things were.
Well, it wasn't just because of that. There were other variables at hand even before stuff with that.
Okay, but you did have in 2018 into 19, you did have some resentment towards your mother based on the way she handled getting over the affair.
That was a factor, yes.
Yes.
That was the only thing.
You had other reasons for resenting your mother, but there's no question that at the end of 2018, beginning of 2019, you had a lot of resentment for your mother.
She was getting aggressive in the fights, yes.
Now, you also, at that same period of time, didn't you? You were also working or began to work, didn't you, for a guy by the name of Mac that you mentioned is close to your family?
Yes, I can't remember what year it started, but I believe I was working with him at the time. I think.
So, were you already working with him, do you think, in October of 2018 when your father told you about the affair, or do you think that only happened after?
I started working for him after.
Okay. So, maybe around the beginning of 2019?
Yes.
Okay.
Yes.
Now, you said that your father, who had been working for Mac doing fire sprinkler installations, started tapering down his work with Mac
Yes.
right after October 2018.
Sure, yeah.
Does that make sense?
Well, yeah.
Okay. Now, as he was tapering off completely, that's when you started to work for Mac. Was there an overlap at all between you and your father?
I don't think we worked
Together.
when I was on the payroll. I don't think we worked together.
Okay. So by the beginning of 2019, that whole thing had sort of ramped down, and you had ramped up, and you were working then with Mac, weren't you?
Yeah, I believe he was already gone by the time I officially started my first day.
Okay. Now, obviously, I don't have to remind you. Mark was a very important part of your family.
Yes.
He was almost like a family member, like an uncle, right?
He was, yeah.
Yeah. And when you first started working for Mac, he knew that you were having some sort of issues at home, like you were having some problems at home.
If you knew, he didn't tell me.
Okay. Didn't you guys have a conversation about he knew all the players, right? He knew your dad, your mom. He knew obviously your siblings. When you first started working, didn't you guys have conversations about the family situation?
Only because I told him what was going on.
And didn't he tell you that he had some sort of skepticism about your dad's drinking?
Yeah. Basis. I'll let him have it.
Didn't he tell you that he had some doubts about your father's alcoholism?
That wasn't part of the conversation, no.
Didn't he express to you during the period of time in which you worked for him that he had some doubts about your father's alcoholism?
That's, from my recollection, that's not what he told me.
He never told you that he had some doubts about your father's alcoholism during the time that you worked?
He just told me of the relationship between the defendant and my dad. That was
Okay.
him.
All right. Page 29, 30. Do you remember coming into my office and having a conversation with me at my office?
I do, yeah.
About a month and a half ago.
Yeah.
And we taped the conversation.
We did.
May I approach, Your Honor?
You may.
Handing you the document, does this look or purport to be a transcript of our interview?
Looks like it.
Okay. And obviously, Mr. Ricci, that's your name, right?
Yeah.
Okay. So it says here, it kind of gave me an idea what happened. And what did he say was happening at the time? Well, like I said, it was pretty much he was aware there was an affair, correct?
Correct.
And that would have been Mark?
Yeah.
Mac.
Or Mac, yeah.
Yeah. So by the time you were working with him, you already knew that there was an affair,
I already knew it.
and he did too,
It seemed like he did, yeah.
based on your conversation.
Yeah.
And then you wrote that my dad claiming that he was an alcoholic, and I say, when he was with him more than I was, like as a kid seeing him have like a beer or something, he would be with him, like a bar or something, but he's saying that he's an alcoholic. And I don't know if that's, so was he expressing doubt, I asked. And you said yes. Do you remember saying that?
I do.
Okay, so Mac was expressing doubt about your father's alcoholism, right?
Well, I think it's more doubt of the situation overall,
Yeah.
especially with the affair.
And then I said, and that was the first time you began to entertain doubt, or you already had entertained doubt. And you said, I had a little bit, but this solidified it for me. Like, because I saw him as a very trustworthy source of resource, so I trusted his words, right?
Yeah.
So in other words, Mark expressed to you during that time that he had some doubts about your father's alcoholism. And if you had some doubts already, your conversation with him solidified your doubts.
It wasn't specifically about alcoholism. It could have been a part of the conversation, but that wasn't
I'm
what we
talking-
were expressing doubt for, though.
But that's the part of the conversation I'm talking about. He did express doubt about your father's alcoholism. And if you had doubts before that, this conversations with Max, this trusted figure, solidified them for you, didn't it?
He did give me a reason to not have that be an option in my head, yeah. But
Mac, you mean?
through body language through him, yeah.
Yeah, because he was expressing skepticism in a bunch of ways about your father's alcoholism. And
Not just that, but overall with everything.
also about his mental health stuff, right?
Sustain.
You know that when your father was working for Mac, he had a company car, correct?
Yes.
A truck, right? Had like a company license plate on it.
Yeah.
And at a certain point after he stopped working for Mac, he ended up returning the truck back to Mac, didn't he? And getting
Yeah, eventually, yeah.
and then he got his own truck,
Yeah.
right? And at the same time that he was working for Mac, he also had a phone that was paid for by MCC. If you know,
I don't know if he gave me a phone or not. I don't know.
okay. But it was clearly sometime in the early part of 2019 that your father stopped working for Mac, or late 2018 that your dad stopped working for Mac, correct?
Sure, I don't know exactly when, but that would be my guess. Would be
Yeah.
early 2019.
Because you started working at the beginning of 2019 for him, and by that time your dad's already sort of out already.
I didn't see him there at all when I first started.
And that was the beginning of 2019, right?
Yeah, around there.
And it would have been sometime in the early part of 2019 that your father changed his phone number, right?
I believe so. I don't know exactly when though.
Okay. It was while you were still living at the house, though.
I can't say for certain. I don't know.
Now, as we said a moment ago, your father was going to AA,
Mm-hmm.
and he also was making a lot of AA friends, wasn't he?
I wasn't there for every meeting, so I don't know. I was only there for two.
2 meetings, you mean?
I believe so. Yeah, for only
Okay.
2 AA meetings, so I don't know what friends he made or not.
Okay. Do you know someone by the name of Bobby Higgins?
Yeah, I met a couple times.
Okay, he's a guy from AA, right?
I believe so. Yeah.
Yeah. You know he was on an AA softball team?
Yes, he was.
Did you know that he did AA bowling?
I don't know about bowling, but I know there was a softball team.
Do you know that the house at 679 Moraine Street became kind of like a meeting point for all the guys at AA or some of the people at AA? Or was that after you left?
That's after I left. I'm sure there was.
Okay. So when you're talking about your father not having any friends post 2018, you really are talking about the old friends like Mac and that circle, right?
Well, the friends outside of Christine being with my dad,
And the friends outside of AA, right?
which are the
Okay.
friends that he didn't. Yeah, outside of
Okay.
AA, yeah.
Outside of AA. You said that Christina told you something about the fact that your father had like memory loss.
I was told that it was memory loss and different mental disorders.
Okay.
Answer stand.
The memory loss part of it, where he said he lost something like 80% of his memory from alcohol or something like that.
Mhm.
Um,
Yes, sorry.
do you think some of that was being said because your father was saying that he had memory loss from 2018?
I was told it from her. From the
Okay.
defendant.
Okay. You never heard your father talk about the fact that he was missing memory or claiming sort of broad-based amnesia for a period of time during 2018
That was, all that information was told through the defendant
to you?
to me.
Okay. And you don't know if your father was saying that and that's why she was saying it. You just don't know.
She was next to him when she told me.
And he didn't say, no, no, no.
He looked there like he wasn't allowed to say a word.
So he didn't respond in any way, in other words.
He didn't, yeah, no.
Okay. Now, obviously, as part of AA, there's various milestones, but one of the biggest milestones is getting a year chip or a 2-year chip.
Sure. Yeah.
And you wanted to support your father, correct? And so you went to his 1-year chip ceremony.
I did.
Okay. And you described that ceremony as being your mom got up and talked for a half hour and your dad only talked for 5 to 10 minutes.
Roughly, yeah.
Okay. Is it your understanding that oftentimes at these chip ceremonies, the chip is given to them by someone who is close to them and has watched their sobriety journey?
No, it's the person going through the process of AA, from my understanding.
But what about the person who gives the chip and grants the chip to the person? Don't they often say words about the alcoholic?
That's
Or do you not know?
not my understanding of it, no.
Okay.
That was the process of the person going through alcoholism.
Okay. Other than those 2 Alcoholics Anonymous meetings that you went to or that you noticed in the house and the chip ceremony, do you have a broad-based understanding of Alcoholics Anonymous?
I have a basic knowledge, but I haven't been to AA, so I don't know the whole process of how it works.
Okay. Was that the only chip ceremony you ever saw?
No.
You've seen another chip ceremony?
It was the first month one too. And then my dad would have all his other chips.
Oh, so you've gone to a month chip
The
ceremony?
month one, yeah.
Okay. It's fair to say, though, that a year chip ceremony is a lot more important than the month chip or the daily chip that you get along the way as far as being a milestone.
I don't think one's more important than the other. I think
That's fair.
a personal adversary that they go to. That's nothing for me to judge.
I completely understand that. I guess let me put that a little bit different. Certainly, a year is a very big milestone, one that obviously you only have once every 365 days.
I mean, the 24 days can be as big as a 1 year.
Yeah, in the individual scenario, but a 1-year chip has special importance and is often treated with more pomp and circumstance because it's such a major milestone.
It can be to other people.
It was a major milestone to your dad that he made a year of sobriety.
I don't know how he felt about it, but it can be as big as going for 24 days or 30 days.
Did he invite you to the 24-day ceremony?
I believe so. I think the whole family went.
Okay. And what about the every month chip after that? Did you go to those? Were you invited to those?
We were invited, but I don't think I went to them.
Okay. You made a special point of going to the year chip ceremony because it was important.
After hesitation, yes.
But you went even after hesitation because you recognized its importance to him.
Yeah.
And you were trying to be supportive.
As I always
Of course. Of course. Of course. So by the time June 6, 2019 rolls around, you've already for several months, maybe as many as 8 months, reached a point where you feel like you've forgiven your dad for what he's done and you wanted to move on, correct? Based on your testimony a moment ago.
Yeah.
And you're also, by then, sort of having feelings of resentment about your mom.
Well, it wasn't just to her. I mean, it was a lot of people to have certain emotions for, but yes, there was.
You were unhappy with the household situation.
Happy with the house in general.
And you placed a lot of the blame at the feet of your mother. Is that fair to say at that time, based on your previous answers to me?
I mean, there was blame to go around. It wasn't just her, but
you did feel a fair amount of resentment towards your mother.
There were some problems, yes.
Yeah. And you'd already been working with Mac for Probably 6 months by then, talking to him.
I don't say it again, please.
You started working for Mac at the beginning of 2019.
Yeah, I believe so.
Yeah, and by June 6, 2019, you've been working for him for about 6 months.
I think so.
Okay. I mean, thereabouts.
Yeah,
I mean, it's not, doesn't need to be super specific, but you're working for him for a number of months by then.
but I can't remember exactly how many months, but
Mhm.
sometime that year.
You recognize that oftentimes when people act, they don't always announce their intentions, correct?
Sure.
And so in order to determine their intentions, you have to engage in sort of an active interpretation based on their actions of what they're intending.
I suppose.
Okay. Do you recognize that sometimes someone's attitudes towards the person whose behavior they're interpreting can affect the interpretation?
How do you mean?
Are you open to the possibility that someone's feelings and emotions about the person whose behavior they're interpreting could affect their interpretation of that person's behavior?
I'll see you at the side of the bench.
Remember that you talked a little bit about the way your father looked during your last conversation with him, which was on January 22nd, 2021.
Yes.
At that time, you had not actually seen your father in about a year and a half, correct?
I believe so. Yes. I can't recall for certain, but I believe that was the last time I saw him.
Meaning that you had, by the time you saw him, it had been quite some time since you'd seen him before.
Yes.
Okay. At the time that you stopped seeing him, about a year and a half before, he was 51 years old, correct?
Yes.
He already had some gray hair.
A little bit, yeah.
Mm-hmm.
Just because of old age, but not because
Right.
of stress.
Right. And so when you saw him at the firehouse,
Mhm.
people's weight fluctuates all the time. Do you agree with me?
I'm sure.
Yeah.
Different for everybody.
Yeah. And because you hadn't seen him in quite some time, there could have been a major fluctuation in his weight over the course of that time.
Through the firehouse? What do you mean?
Well, what I'm saying is you hadn't seen him in a year and a half. So the ordinary fluctuations of weight that you would see in the ordinary course of seeing someone, you would have missed all that.
It's possible, yeah.
Yeah. And so
I've seen pictures though.
you saw pictures of him.
Yep.
Okay. And as far as timing of those pictures, were those closer to the time you left the house or closer to the time that you talked to him?
Closer to the last time I talked to him.
Okay. Now, when you last talked to him, do you know if that was the end of a shift or the beginning of a shift that you were talking to him?
I don't know. I don't know what his schedule was.
Okay. Well, you know that his schedule at the firehouse is 24 hours on, followed by 2 days off, 24 hours on, followed by 4 days off, right?
Again, I don't know his schedule, but I know he did 24-hour shifts. I just know what days he was off in between.
Okay. So you know that he had a 24-hour shift.
I didn't know that, yeah.
And so that would be like a 12-hour shift overnight and then another long shift the next day.
I don't know. Sure, but
But that's what a 24-hour shift would
sure,
be,
yeah.
right? Okay. So if there had been, for example, would he spend the night between those two shifts at the firehouse?
Yeah, we spent the night at the firehouse, yeah.
And when he spent the night at the firehouse, if there had been a call, that would have disturbed his sleep, correct?
Yeah.
Yeah. So do you know if he was at the end of his 24-hour shift or the beginning of his 24-hour shift?
I don't know. I didn't ask him. I don't know what
Okay.
schedule was at that.
All right. So if he had been on for 24 hours straight and you were seeing him at the end of a shift, would not be that unusual for him to look tired, would it?
I mean, I've seen him at a 24. I was with him a couple of times.
Right.
I was during a 24-hour shift.
When he was a much younger man.
When I wasn't too young when I went with him. It had been like 6 years ago. I don't know if that hasn't. He's been doing it for over 23 years, and he's doing the same throughout those 23 years.
And there are lots of variables that can make a shift more tiring or less tiring depending on what happens overnight.
It can be.
Right. And you just don't know that information, right?
No.
Right. Now, do you agree with me that you told the story about the firehouse at grand jury all the way back in 2021?
Objection to. I'll see you at the side of the bench.
You described the event at the firehouse, that last conversation with your father at grand jury. Do you remember that?
I don't know. I don't remember if I did.
Your testimony today is that you may have seen a bruise on him,
Yes. May have seen one, yeah.
but you're not
I
100%
can't say
sure.
for certain.
Okay. When you spoke to the grand jury, your goal was to tell them
The truth.
essentially everything relevant that you knew that was the truth, correct?
I told him the truth.
Right. And you tried to tell them, to the best of your memory, everything that was important that you knew.
I told him what the truth was, not what I thought was important.
But you told the truth, but you told the truth based on what you thought was being asked of you and based on what you thought was important given what the question was, correct?
Correct, out of what I saw when I was there.
Right. And today you say that there may have been a bruise.
There could have been.
There could have been a bruise. Okay. Is your memory exhausted with regard to whether there was?
No, but that was 3.5 years ago when that happened. So
Okay.
I remember it. We were there a week after it happened, so details are kind of foggy.
Would the fact that your father had a bruise be an important observation, do you think, or a significant observation, do you think?
I just told him what happened, what I was doing there for.
Mhm. But do you think that it's something that would have stood out in your memory, certainly, if you'd seen a bruise?
It could have, but I wasn't looking at that. I told him what I was there for, but I wasn't paying attention to if he had marks on him. I was there just to talk to my dad. I wasn't too focused on if he had any injuries on him.
Okay, so you don't know if he had any injuries on him.
I'm not too certain.
Okay. And you don't have it. Do you have an actual memory of seeing a bruise, or you're doubting that? I don't
He
know.
can explain to the jury what his best recollection is of whether it's dad had a bruise when you saw him that.
I did see, like I said, I do remember seeing bags under his eyes,
Okay.
but there could have been darker spots that were right below that too, below the eyes itself.
Okay. You remember having that memory, or is it sort of a surmise that it could have been the bags could have hidden the black eye?
No, it's thinking about it now. I'm starting to remember what he looked like.
Okay. May I approach, Your Honor?
Given the limitations of what I said,
Yeah.
I think it's appropriate, yes. You may.
Yep.
Like the grand jury transcripts?
Yeah.
That's your name there?
Yes.
Just so I'm clear, this is the area of the transcript that talks about that last meeting, correct?
I believe so, yes.
Okay. Could you just look through that?
Yeah.
Transcript and just yourself, and just raise your hand when you see the part about having a black eye.
What's using this? I never mentioned any of his physical appearances here, including his.
Thank you, this is good.
Now, you mentioned after you left the home, you would be in regular contact with your siblings,
My sister.
your sister Sophia,
Yes.
and you heard in the sort of weeks before was it a week before you sat down and had that conversation with your father that you heard something about a text saying they're fighting again?
From when I met him at the firehouse,
Yes.
it was either sometime that week or the week before.
Okay, so it's within about a week of that.
Yeah,
So that-
the first met. Yeah, when I
Okay.
met him.
When you heard about the fighting from Sophia, was there any mention that it was physical fighting or just verbal?
She just told me they're fighting again. I want to get out of the house.
Okay. There wasn't any statement about physical fight.
I can't remember what I said on the text or what was sent to me.
In fact, Sophia, you don't remember Sophia ever describing a physical fight after you left the house. Isn't that right? Just verbal.
I can't remember. A few years ago. I would have to look back and see what she sent to me.
Okay. But as you stand here right now, nothing stands out with regard to Sophia telling you about physical fights after you left the house.
Not the top of my head, I can't remember.
Okay. Now, you mentioned earlier that you and Mac perhaps had some doubts about your father's alcoholism. Did you ever get a sense that you believed that your mother believed that your father was an alcoholic, right?
And she was pretty involved in the process. So yeah,
And she would go to like Al-Anon, correct?
including Al-Anon, yeah.
Yeah. And she would read the AA books, correct?
I don't know what she read enough, but
Okay. And you're also aware that she was going to school at Quincy College, right?
Yes, I was aware.
And she was studying some sort of psychology.
I don't know what she studied.
It was your understanding that one of the reasons she went back to school was to try to understand what was going on with your father?
I don't know. She told me that she wanted me to be proud of her, that she was going to school.
Okay. Did you have a sense that one of the reasons that she went to school was to try to figure out and support your father, though?
Can you answer it if he knows?
Can you repeat the question?
Yeah. So, for example, when she decided that she was going back to school, did you have a sense that she was doing so in order to help support your father?
I don't know. That wasn't important to me at the time.
Okay. Now, we talked on direct examination a little bit about the layout of 679 Moraine Street.
Mm-hmm.
We also talked about that large living room, dining room area.
The open floor plan, yeah.
Yeah. That was connected to the kitchen, correct?
With 2 steps, yeah.
2 steps. About how high up were those 2 steps? A little over a foot?
Maybe, yeah.
Yeah. On June 19th, when your mother grabbed the knife was it from the kitchen drawer or was it from the block of knives?
Say that again?
You said that you were there when you saw your mother grab the knife on June 6, 2019?
Yeah.
Was that from the drawer or was that from the block of knives?
I don't know which one, but there was a block of knives, and right above it was a magnet that held kitchen knives on that too.
And do you remember where she got the knife that she grabbed?
I can't remember which one, but it seemed to me it was more reasonable that she grabbed it from the magnet. That was easy to just grab.
And you were there when she grabbed it?
Yeah,
Within a few feet of her, like 3 feet of her?
that was behind her. Yeah,
3 feet behind her. As soon as she grabs that knife, at that moment, you go into action, right?
yeah.
And that's when you sort of do sort of the reverse. Is it more like a full Nelson or more like a bear hug?
No, it was wrapped. My arms were wrapped around her, like around her backside, but around her arms. So her arms were back like this.
Did she, when you say that she grabbed the knife and she moved, how far did she get towards that threshold, the 2 steps of the living room, dining room before you were able to stop her?
There's probably like a step or 2 from where the knives were.
Okay. So she only was able to get about a step from where the knives were when you stopped her. She was still in the kitchen.
Yeah, she's in the kitchen.
And then you brought her and sat her down in the
Yeah.
chair, still in the kitchen.
Yeah.
Okay. And your father was outside one of the doors that went off that living room, dining room area.
He went through the side door, but he's still visible through the screens.
You could see him through those windows, correct? Is that what you mean?
Yeah.
Right. But meaning if you're in the threshold between the kitchen and the living room, dining room area, you can see through those screens. Is that what you mean?
So, wait, say it again?
So where can you see through those screens? Is it in the kitchen or is it in the steps leading down to
in
the
the
kitchen?
kitchen, you can see it
Okay. So he's in off of the living room, dining room area, correct?
outside. Yes.
Yeah. And your mother is in the kitchen the entire time during that interaction.
Yeah.
How tall was your father?
I don't know how exactly to tell, but maybe like around 6 feet, a little bit bigger, maybe.
And your mother?
I have no idea. Maybe 5'4", 5'5", maybe. I don't know.
Good afternoon, sir. Just a few questions for you. Defense counsel asked you about the time when your father shared with you that he was an alcoholic, and you used the word confusion on your part.
Yes.
Can you explain why you were confused about that?
Me and my sister were having conversations of
Objection, Your Honor.
All right, not to the conversation, but why were you confused by that revelation?
to me, I don't know what alcoholic meant, but it didn't seem like my dad. We were just described of how alcoholics were, and he didn't fill that criteria to us.
Objection, and move to strike the
I'm
else.
gonna just ask you to limit that answer to
Sorry.
your own confusion, sir.
Sorry. He didn't seem like an alcoholic.
Okay. And defense counsel asked you about end of 2018 and the fact that the affair kept being brought up to you and how it bothered you that it kept being brought up. And I believe you said it would have been nice if the defendant didn't bring up the affair every day. Is that right?
Yes.
Is that how it seemed to you, or is that how it was, that she was bringing it up every single day?
It was every time.
And you also indicated defense counsel was asking you a number of questions about your potential resentment towards the defendant. You remember that line of questioning?
I did.
And he asked you, and that was because of the affair, and you indicated that wasn't the only reason?
Yes.
Were there other reasons you resented her?
It was
Fair game. Let him answer.
how she was being physical and how she was verbal towards everybody in the family.
Objection, Your Honor, move to strike.
See you at the side of the bench.
Sir, just to go back, you indicated that wasn't the only reason that you resented your mother because of her bringing up the affair every day. Could you answer that again? Why else were you resentful of her during this time period?
She was being physical with everybody in the family, very violent, and how she was treating different family members.
And with regard to Mac or Mark McDonald, that was brought up, that line of questioning, and defense counsel was asking you about whether basically Mac's doubting your father being an alcoholic affected you. Did it affect you, or did you have your own independent doubts?
I had my own thought on it, and he kind of like agreed with what I thought about. So, but I mean, that wasn't the only thing we talked about. It was just like everything as a whole of what was going on.
And in terms of the line of questioning about how you were about your father's purported memory loss, and I believe you indicated you were told about his memory loss. Is that right?
Yes,
Who were you told about his memory loss by?
the defendant.
And just to be clear, during all the time you lived with your father up until June 6, 2019, and any time thereafter that you saw him, did you have any red flags about any kind of memory loss?
Absolutely not.
And did you have any red flags at all about your father being an alcoholic before 2018?
Absolutely not.
And Defense counsel asked you a couple of questions about the 1 year CHIP event from AA. You recall that line of questioning?
I do.
And I believe you indicated that you said your father looked like he wasn't allowed to say a word. Is that right?
100%.
Can you describe that?
He, for when he was up speaking,
Objection, Your Honor. Objection.
I know your continuing objection. You may answer.
so can you repeat the question?
Yes, I believe you indicated that your father at the AA 1 year CHIP meeting looked like he wasn't allowed to say a word. What makes you say that?
All he said was, thank you, for done with my family. And then Christine kind of shoved him over to go to the microphone.
Objection, Your Honor.
Do you want to be seen? Would you like to be seen, counsel?
No, Your Honor.
All right.
So
The answer will stand.
thank you. The defendant shoved him over so she can speak essentially,
Yes.
and then she continued to speak for 30 to 40 minutes, I believe you said.
Yeah, around 30 minutes, yeah.
And why did that stand out in your mind, sir?
Because
Sorry.
she was talking about her experience on why she stayed and how she got on her hands and knees, or my dad got on his hands and knees and begged her to stay when she had her bags packed to leave him. And that's why she decided to stay.
Was it kind of all about her?
Yes.
He also indicated defense counsel was asking about other CHIP events and whether or not you attended them. And then with regard to the 1 year CHIP event, you indicated after some hesitation, you went to that event, correct?
Correct.
What was your hesitation, sir?
A month prior, I got into altercation with the family at the house. My sister texted me, or she,
Objection.
I'll ask you another question.
Abstain.
So you had some hesitation about going?
yes, because
Dude,
we got an
dude.
altercation with the family at the house.
Okay. And did Mac influence you about how you felt about your mom in general?
No, he kept his personal opinions about her to himself. He was there to listen about what I thought about her.
Sir, I know you've described a lot of difficult things involving your mom and your relationship with her and what you witnessed. Is it fair to say you also had a positive relationship with her at times growing up?
I did.
Could you describe that?
We would always crack jokes. Sometimes when I was younger, I didn't know how to cook, so I would make a small, like, half-assed dish. Sorry for language, but we would watch TV shows, like TV shows we were both interested in. And even when I was in middle school, we did a little bit of like Zumba, like an after-school curriculum. So at that time, it seemed like a loving relationship between the two of us.
Did you love her?
I did.
And with regard to what you may or may not have testified at grand jury soon after these events, fair to say you were never asked to describe anything about your father's physical appearance when you visited him on that last occasion at the firehouse, correct?
Correct.
You were strictly asked about your conversation with him, correct?
Yes.
And I believe you were beginning to say you're now picturing in your head what your father looked like on that last visit, correct?
Correct. It's coming back to me a little bit now.
And could you describe that, what
Yep.
you're visualizing?
Like I said, bone definition was pretty clear. Bags under his eyes, white hair, seemed tired, skinny. Like I said, I remember seeing a darker spot under his bags, kind of closer to like around his cheekbone, if anything.
Did it appear to be a bruise?
Like towards the end of a bruise, yes, but it didn't seem new.
One moment, please. Nothing further.
Recross.
Could we approach sidebar briefly?
Yes.
Nothing further.
Thank you. The witness may step down.
Thank you.
Hold on one second.
Commonwealth calls Dr. Martinez. Oh,
It's all right.
oh, I'm sorry.
We'll just hold up when she gets in
Okay.
here. If I'm not done.
Good afternoon. Do you solemnly swear that the testimony and the evidence that you give to the court and the jury and that are now coming from the Commonwealth and Senate of Bar to be the truth, the whole truth, nothing but the truth, so help you God? Thank you.
Just hold on one second, counsel.
Absolutely.
You may proceed, counsel.
Thank you. Erin. Good afternoon, ma'am.
Hi,
In a loud, clear voice, could you please introduce yourself and spell your last name?
okay, yes, my name is Maria del Mar Capo Martinez. Last name is spelled Capomartinez.
And just so the record's clear, is your first name Maria?
First name is Maria del Mar,
And you're saying Maria Del Mar, Delmar? Two
Yes.
separate words?
2 separate words.
Okay,
yes.
thank you. I just want to make sure for the
No
record. And then after that is Capo or Capo?
Capo Martinez.
Okay.
Yes.
Thank you. And where do you work, ma'am?
I worked as a medical examiner in the medical examiner's office in Boston.
How long have you been employed there?
I've been there for 8 years.
And in what capacity are you employed with the medical examiner's office?
I'm one of the medical examiners that works in the office.
And what are your duties as a medical examiner?
Basically, I perform routine examinations and autopsies to determine the cause and manner of death on death in the state of Massachusetts.
And could you please describe your educational background, doctor?
Yes, I have a bachelor's in biology. I obtained a medical degree in Puerto Rico. Then I did 4 years of residency in Stony Brook University Hospital in New York. And then I did 1 year of fellowship training in forensic pathology here in Boston.
And you may have just covered this in the last answer, but where did you do your residency? Was that in Boston?
No, Stony Brook University in New York.
Thank you. Are you board certified?
I am board certified in anatomic pathology as well as forensic pathology.
And what does board certified mean?
It means that you're an expert in your field. You've pursued further education within certain specialties, and you've gone a further length to take rigorous examinations to be declared board certified.
When did you become board certified?
2020 for anatomic pathology and 2021 for forensic pathology.
Have you had any academic appointments?
No.
And have you ever testified as a specialist in pathology?
Yes, multiple times.
Have you performed autopsies to determine causes of death and the nature of your job?
Yes,
How many autopsies roughly have you performed?
We do a mix of autopsy examinations and just external examinations. Combined with the two, I'm upwards of 2,500.
And could you please tell the jury what is involved in an autopsy, doctor?
Usually we define it as 3 parts. One part is the external examination, which is where you look at the body, you notice any marks on the body, injuries, any scars, any sort of thing that catches your eye, as well as weight, height, hair color, eye color, all those sort of descriptors. Then there's the internal portion of the examination where you perform a wide incision and open the body cavities and examine the internal organs and any either natural illnesses or any injuries that these organs may have. And then the third part is the review of the chart, which you kind of do throughout the whole process. You do it before, you do it in between, and you do it after, which may consist of reviewing such things as x-rays, toxicology reports, police records, EMS records, medical records, etc.
And how long does an autopsy take?
It can take from an hour to several hours. It depends on the complexity of the case.
And do you typically report your findings into a written report?
Yes, there's a standard anatomy diagram that we use. Everybody uses the same one. There are other varieties, so you may add diagrams depending on your necessities, but for the most part, yes, there is a standard body diagram.
And how many autopsies have you conducted involving deaths as a result of stab wounds or sharp wounds?
I don't have an exact number off the top of my head, but several.
And based on your training and experience, are there different types of wounds from sharp objects?
Yes.
Can you describe those, please?
There's incise wounds, there's stab wounds, there can be chop wounds. Yep.
What are stab wounds?
Stab wounds are forensically defined as wounds which the depth of penetration is longer than the width of it on the skin surface. And an incised wound is longer on the skin surface than it is deep into the tissues.
And what are perforated wounds?
Perforated wounds are wounds that go through and through.
Have you, and do you have experience in determining a wound path, doctor?
Yes.
What is a wound path as it relates to referencing this case, which we'll get into?
So a wound path would be the path of tissues where whatever implement was used goes through.
Are you able to determine the depth of a stab wound?
Yes.
How?
We usually use different sets of probes, and so you get a probe length.
And doctor, did you have occasion to perform an autopsy on Michael Ricci Sr. to determine his cause of death?
Yes.
When was that, doctor?
January 29, 2021.
And in the course of your conducting the autopsy of Michael Ricci, were you able to determine his height and weight?
Yes, he was 5'10" and 188 pounds.
Did you conduct an external examination of Michael Ricci?
Yes.
And did you chart the injuries you found on the body?
That's correct.
Can you describe to the jury what, if any, observations you made of his injuries?
He had a wound to the left side of his chest, a wound to the left side of the back of his torso and a wound to the middle of his back. A sharp first injury.
May I have one moment, please?
You may.
Thank you. May we approach, Your Honor?
Yes.
Thank you.
Jurors, I want to give you some instructions on autopsy photos. Jurors, you are in a minute going to be examining or looking at autopsy photos. I recognize that this is not pleasant. The fact that they are so, that is the fact that they're unpleasant, may not influence your verdict in any way. Defendant is entitled to a verdict based solely on the evidence and not based on sympathy, pity, anger, or passion. These photographs may be considered by you only to the extent that they draw your attention to a clinical medical status. You may proceed.
Thank you. May I approach?
Yes.
Doctor, I'm just going to ask you to take a look at this first photograph and tell me if you recognize what that is a photograph of.
It's a photo of the autopsy, Mr. Ricci.
And specifically, is there a number associated with the particular injury you're viewing?
Yes, number 1.
And is that a fair and accurate depiction of one of the wounds that you examined on the body of Michael Ricci?
Yes.
I'd ask this be marked as the next exhibit, please.
Any objection to that photo? No, Your Honor. It'll be marked as Exhibit 48, autopsy photo number 1.
May I publish it at this time?
You may.
Showing exhibit 48, and just for identification purposes, what are we looking at here?
This is just a portion of the photograph, but you can see a ruler, a wound, and this is the left torso, anterior torso of this person.
And it's identified as number 1, correct?
Yes,
And
and
why is it
Just a way of documenting the injuries. When there's more than one injury, usually it's at the discretion of the doctor. I tend to use numbers for them.
You may.
And I'm asking you to take a look at another photograph and tell me if you recognize that photograph, ma'am.
Yes, this is a close-up look of the same wound.
Um, And is that a fair and accurate depiction of the one that you examined?
Yes.
I'd ask that this be marked and published.
Any objection to that photo? It'll be marked as Exhibit 49, the close-up of number 1.
And just to show the jury, that's the photograph of wound number 1 that was measured, examined, and labeled as number 1, correct?
Yes.
And at this time, I'd ask with regard to that wound number 1, if you could describe that wound.
So based on my findings, this was considered a stab wound. It's about 3 centimeters long. And it probed to 15 centimeters in depth. The wound path or the injuries along the tissues are through the subcutaneous soft tissues, which is just the fatty tissue under the skin. It pierces through the left fourth rib cartilage. Then it pierces the pericardium, which is a membranous sac that holds the heart. Then it pierces the heart in multiple areas, including the right ventricle and the interventricular septum. Associated injuries with these are a hemopericardium, which is an accumulation of blood around the heart, a collapsed left lung, and a hemothorax, which is an accumulation of blood around the left lung in the left chest cavity.
And in terms of when you indicated the probing, that's to determine the depth that you described earlier, correct?
Correct.
And you indicated that was 15 centimeters, is that correct?
Yes.
Are you able to, with your hands, show the jury what 15 centimeters looks like?
I would say maybe about this big. It's about almost 7 inches, probably.
Objection, Your Honor, may I be heard sidebar?
Yes. Or as I told you that on some occasions, the parties will reach an agreement with regard to a fact, and that's one of those facts. And I'll tell you, you can take that back to the bank. The parties have agreed, and I'll give you judicial notice that 15 centimeters is translated to 5.906 inches.
Thank you. May I approach again, Your Honor?
Yes.
Thank you. I'm showing you another photograph. If you can tell me if you recognize that photograph,
Yes.
and what do you recognize that photograph to be?
It's wound number 2, or wound label number 2.
And is that a fair and accurate depiction of wound number 2 that you examined?
Yes.
I'd ask that this be marked as the next exhibit.
Any
and
objection to that one?
Your Honor.
It'll be marked and admitted as Exhibit 50, the wound number 2.
And do I have the court's permission to publish it?
You may.
I'm showing you what was just marked as Commonwealth Exhibit number 50. And just so we're clear, excuse me, what are we looking at here?
Is wound number labeled number 2.
And in terms of the location, although some might think it's obvious, where is it located, wound number 2?
It's in the back of the shoulder / torso. What's your torso?
I'm sorry. So is that the back of Michael Ritchie's shoulder area?
Yes.
May I approach again?
You may.
And I'm showing you another photograph. Ask if you recognize that photograph.
It's just a close-up look at the wound.
And is that a fair and accurate depiction of wound number 2?
Yes.
I'd ask that this be marked as an exhibit.
Any objection to that page, that photo? All right. It'll be marked and admitted as Exhibit 51.
May I publish it, Your Honor?
You may.
And fair to say this is just a close-up of injury or wound number 2, and it's shown next to a ruler.
Yes.
And the purpose of the ruler.
It's always just to show the size of the wound.
And could you describe that wound number 2 as you did similarly with wound number 1?
So that wound, like I said, is in the back of the shoulder and torso area of the decedent. It's about 3.1 centimeters in length. It probed to 6.6 centimeters in depth, and it's mostly affecting, or the wound path is through the soft tissues and the musculature of the shoulder and the back.
And with regard to wound number 1 and wound number 2 that you just identified and described, are you able to establish what type of weapon was used to instill these injuries?
I can tell that it was a sharp instrument and likely a knife.
May I approach?
You may.
Just going to ask you to take a look at this photograph first. Do you recognize what that photograph is?
Yes, it's the hand of the decedent.
And is that a fair and accurate depiction of one of the hands of the decedent?
Yes.
I'd ask that this be marked as the next exhibit.
Same objection.
I know your objection, your additional objection to this exhibit. I overrule it. It'll be marked as Exhibit 52. Is this labeled as a wound number?
No.
Okay,
Oh, sorry.
all right.
I'm not
No, I can
listening.
ask your question. No wound number.
No number.
May I approach again?
You may.
Thank you. Ma'am, I'm going to ask you to take a look at this other photograph. Do you recognize that photograph?
Yes, it's the same hand, but from a different angle.
Is that a fair and accurate depiction of that hand that you examined?
Yes.
I'd ask that this be marked as an exhibit.
Same objection. It'll be marked as admitted as exhibit 53.
May I publish these drawings?
You may.
Now I'm just showing you, what was marked as exhibit number 52. That is the hand that you identified of Michael Ricci, correct?
Yes.
And a different angle, same hand, indicated, exhibit number 53.
I'm sorry, I couldn't hear you.
I'm sorry, I'll repeat. Just showing you, as you described it, a different angle of that same hand is exhibit number 53, and that's this picture, correct?
Yes.
And how would you categorize, or what would you call the injuries on his hand?
I identified these on my notes as being abrasions, fresh ones.
And how are you able to identify them as fresh?
By the color and the quality, they're red and they're not dry, they're still wet, they don't have a scab on them. So an abrasion is pretty much like a scrape that you get on your knee when you fall.
May I approach?
You may.
And asking you to take a look at this photograph and tell me if you recognize it.
Yes, that's the third one. I don't believe it's labeled in this photograph, but that is the third wound.
And is this a fair and accurate depiction of the third wound?
Yes.
I'd ask that this be marked as an exhibit.
Any objection to that photo?
Renew my objection from earlier with regard to this third one. Should we be heard at sidebar, Barbara?
Yes.
Okay.
I'd ask again that this be marked as an exhibit, please.
Yes, I will admit that the photo of wound, the third wound, as exhibit 54.
May I approach again?
Yes.
Doctor, I'm just showing you another photograph. Do you recognize that photograph?
This is the same photograph, it just doesn't have a ruler or a marker on it.
Is this a fair and accurate depiction of that same injury as the prior photograph?
Yes.
I'd ask that this be a
Same objection.
Yes.
It'll be marked and admitted as exhibit 55.
May I publish these two photographs?
You may.
Showing you what was
This one's in the decedent's back.
Um, And now showing you just, you indicated it was same injury, exhibit 55, as exhibit 54, is that correct?
Yes, it just doesn't have a marker or ruler on it.
And could you describe that wound?
This one's what we consider an incised wound. So this one's 2.8 centimeters long, but it only probed to 0.1 centimeters in depth into the soft tissues. So it's very shallow, which is why it's considered an incised wound.
And the wounds to the decedent's hands, are you familiar with the term defensive wounds?
Yes.
And what do you understand defensive wounds to be?
Wounds that are created as part of the victim defending themselves from an attack.
And are you able to categorize certain wounds as defensive wounds?
Maybe we can see it some-
Yes.
Ma'am, with regard to the abrasions, I believe you described them on the decedent's hands, as shown in exhibit 53, are you able to determine whether or not, one way or another, whether or not these are defensive wounds, or is that something difficult and impossible for medical examination to determine?
I cannot determine it based on these particular ones.
And ma'am, were you able to determine the cause of death of Mr. Ritchie?
Yes.
What was it?
Sharp force injuries of the torso.
Could you explain to the jury how you were able to determine that?
Given the wounds are all located in the torso and they're resulting in injuries to major organs in the torso area. That's how I came to that conclusion.
How long would an individual survive after the wounds that you just described?
It really varies from individual to individual. I believe I wrote in my death certificate that this was from seconds to minutes, based on scene information and medical personnel information.
And based on your training experience and your examination of the wounds, what would Mr. Ritchie be physically experiencing internally during the moments after the stabbing?
Objection.
She can answer.
Based on the fact that he had a hemopericardium and a hemothorax, as well as soft tissue injuries and organ injuries, he would have likely had some pain related to the wound. The collection of blood around the heart and around the lung would likely make it difficult to breathe. It would likely make it difficult for the heart to contract. So he may have been short of breath. He may have had rapid heart rate until he lost consciousness.
And would, in terms of the amount of blood that was outside, externally observed on Mr. Ritchie, are you able to give your, based on your training experience, an explanation as to why there would not have been a lot of blood either at the scene or on his person?
I didn't see any scene photos, so I don't know what the scene looked like. I only saw what the internal findings were. He had 1,550 milliliters of blood in the left chest cavity and 275 milliliters of blood around the heart. So that's a considerable amount.
And why would, when you say that's a considerable amount, what do you mean?
On average, approximately, people tend to have about 5 liters of blood in their system. So this is about 1,800 milliliters. So a little less than half of the blood volume was within the heart cavity, or the heart sac, sorry, and the left chest cavity.
So a lot of the blood was internal.
Yes.
And at this time, I'd offer the death certificate, Your Honor, as the
Any
next
objection
exhibit.
to the death certificate?
You can offer it as the next exhibit, subject to redaction, Your Honor.
Yes. It'll be marked and admitted as Exhibit 56, subject to redaction.
And Doctor, in terms of the materials you reviewed as part of the examination, did that also include the South Shore medical or hospital records of Michael Ritchie?
Yes.
I'd offer those records as the next exhibit, subject to redaction, Your Honor.
Any objection to that? Subject to the redaction.
Subject to the redaction.
It'll be marked and admitted as Exhibit 57.
You have one moment, please.
You may.
Just a couple more questions, ma'am. Are you able to discuss or tell us about how much force it would take for a knife to go through what you described, cartilage of Mr. Ritchie's ribs, heart, and collapse his lung ultimately?
I don't know how I can describe how much force it would take because it varies on multiple different things.
And could you just briefly describe the different densities of tissue that the wound went through?
Well, it went through skin, it went through fatty tissues, it went through cartilage, it went through muscle. Those tissues obviously have different consistencies and densities, but this also depends on the type of implement that is being used.
And in terms of the density differences between skin, for example, and muscle and cartilage, are you just able to briefly describe the difference in densities?
So skin's very elastic, fatty tissue is, very soft, cartilage is very firm, muscle is pretty firm as well. But I don't know how that would impact the force.
But based on your examination, is it fair to say both injuries, number 1 and 2, went through skin, fatty tissue, cartilage, and muscle?
Injury number 1. Injury number 2 only went through skin, fatty tissue, and muscle.
Thank you for clarifying. If nothing further at this time.
Cross-exam.
Good afternoon, ma'am.
Good afternoon.
You mentioned, just to pick up on that point from a moment ago, it's very difficult to tell something about the force in which something went in just based on the wound alone. Is that right?
Yes.
You can tell a little bit about what something may have had to travel through. But for example, it's very difficult from that to tell something about the speed with which the implement was going when it entered into the body, correct?
That's correct.
And
Counsel, I just noticed that it's 1 o'clock, and I expect I don't want to presume the length of your cross-examination, but if it's more than 5 minutes, we're going to probably suspend and pick back up.
it's longer than 5 minutes. Can I finish this?
Absolutely. Finish your line of questioning.
Okay. Obviously, the speed with which the implement enters the body is going to be predicted by the speed with which the hand that held it was moving, but it could also be affected by the speed with which the body in which it penetrated was moving towards the blade.
That's correct.
Right. So if, for example, a close to 6-foot man, about 200 pounds, were to fall with his full weight onto a knife, that could, for example, cause the knife to go in at quite a velocity or with a lot of force.
Correct.
Right. And this one last point, and then I'll finish up, Your Honor. Now, there are scenarios in which a a penetrative wound can be longer than the blade that caused it.
Yes.
And that situation is one in which the force in which it enters the body compresses the soft tissues on top of the wound such that the blade extends further into the body than the length of the blade.
That's correct.
And that could also be a scenario in which a grown man from a height of about a foot fell onto a blade with their entire body weight.
That's possible. Yes.
Until after lunch.
Jurors, we're going to suspend for your lunch break, and we'll be back with you as soon as I finish my afternoon list.
This court's now in session, be seated, please.
Any further cross-examination?
No further cross-examination, thank you.
All right. Any redirect?
No, Your Honor.
The witness may step down. Commonwealth may call its next witness.
The Commonwealth rests, Your Honor.
So what that means, jurors, is that the Commonwealth has had its opportunity and has now completed the evidence that it wishes to present in this case. I'm going to see the lawyers at the side of the bench.
So jurors, I'm going to send you off for your day. I will tell you that I expect that the evidence in the case will close at some point tomorrow. And then we'll move on to the other phases of the case. So tomorrow will be a full day for you. And you may in fact get the case tomorrow, but no promises as to that. Possibility, I just don't know how things are going to turn out. So be obedient to your rules, please, jurors. I know you've been obedient to them at this point in the case. As I've said, you probably could recite them and start asking each other. Don't do that, but be obedient to those rules. Don't talk to anyone about this case. Don't do any research about this case, and continue to have open minds until you reach the time that you'll deliberate the case. Have a good night.
Court now rise for the adjournment, this place is no focus in the chair.
Oh, jurors. I almost sent you back out without the most important part. You do not need to be here until 10 a.m. tomorrow. I don't want you here waiting around for us. Be here at 10 a.m. ready to work, all right?
Jurors, please exit this way.
Let me take a moment to look at the motion. All right. Defendant presented a motion for required finding of not guilty at the close of the Commonwealth's case. I've read the motion, Attorney Wood.
I'm asking you to allow my motion, but in particular with regard to the charge under the theory of extreme atrocity. I think under the circumstances and given the nature of the evidence that charge or under that theory should not go to the jury.
Commonwealth is arguing.
Your Honor, at this stage, the Commonwealth suggested in the light most favorable of the Commonwealth that the charge of extreme atrocity or cruelty should go to the jury. As Your Honor is aware, the Castillo case from 2020 informed on how to determine that element of extreme atrocity and cruelty. And these arguments kind of dovetail into the argument for jury instruction as well. But in this circumstance, the revised instruction in the model, the SJC model instruction on homicide, identifies three particular factors, and they're commonly referred to in common law and in prior case laws, the commune factors, and the Castillo obviously kind of revises the order or the importance of those particular categories. Instead of making them several separate and distinct factors, it kind of groups them into three. And so in this particular circumstance, the Commonwealth alleges that there are a couple different elements of the extreme atrocity and cruelty prong that, in the light most favorable to the Commonwealth, are present in this particular case, based on the evidence and all reasonable inferences that can be drawn from that evidence, including one, that the defendant was indifferent as to the injuries. And again, we're not talking about the specific intent of the defendant, the intention of the defendant to inflict extreme atrocity or cruelty by her actions, but it's the conduct and whether that conduct meets the criteria of the element. And so for indifference in this circumstance, the Commonwealth would allege that in this circumstance, based on the evidence, it's not clear that, as defendant promised in opening, that this all happened in a short 15-minute time frame. What you do have before you, Your Honor, is that the last time Michael Ricci is seen by somebody outside the household was 2 o'clock that afternoon of January 28th when he goes to the Dunkin' Donuts drive-through. And you have testimony from Sophia that she gets home from school around 2 in the afternoon. I believe her testimony, based on my recollection, is that she doesn't recall exactly seeing her dad when she came home from school, but she knows both of her parents were home that afternoon. And she heard them. She went right up to her room. She was in her room for the entire afternoon. She heard throughout the course of the afternoon yelling from both of her parents, loud noises. I think she described them as bangs. And it wasn't until 4:45, right before she made that 911 call, when she's called downstairs by her mother, alerted that something had happened. And she discovers and she finds at that time that her father's already on the floor and he's unconscious and not breathing. So we do have a bigger time span than what was alluded to by the defendant in his opening statement about how long this interaction lasted and when this event could have occurred. You also heard from the medical examiner that the nature of that injury and the fact that there was significant injury internally that resulted from the stab wound itself could have led to the unconsciousness of the victim a matter of minutes or longer. So I would suggest, and again, based on reasonable inferences, that the nature of that injury and how it was inflicted and the time frame suggests that the defendant didn't take immediate action, and that is a level of indifference. It also suggests that the injury of itself was excessive and out of proportion. As Your Honor is aware, under the Glass case, which is cited in the model instructions, a single blow is sufficient. And again, a single stab wound, a fatal stab wound, could be sufficient. In here, we have 2 stab wounds, but I think it's clear based on the medical examiner's testimony that wound to the chest that caused all that internal damage was essentially the fatal injury. And that in that injury, the extent of that injury, the victim had accumulated half of his blood volume in his chest that was still there at the time of the autopsy. So I'd suggest that the nature of that particular, the extent of that particular injury is excessive and out of proportion. And I would also suggest that in that third prong, that the method and means, again, based on those other factors that can be considered, where one of those factors does include the level of suffering, the likelihood of substantial increase of conscious suffering of the victim, based on the medical examiner's testimony about what an individual feels or could feel or is likely to feel in receiving that type of injury, the pain of the wound, the loss of breath, the increased heart rate before losing consciousness, that all goes to pain and consciousness. And again, we're not saying that it's just based on what he felt, but these are things that not only did he feel, but the defendant being right there over him at the time would have seen him exhibit. And again, based on the fact that she inflicted that conduct, I think that meets that prong as well. So I'd ask that you deny the motion as to extreme atrocity and cruelty.
So with regard to the 3 Canine factors,
Castillo factors.
well, I'm talking, yes, they're Castillo, but they're
They were
taken
revised in
over and
Canine,
revised
right.
under Canine and referenced as that by the Commonwealth. I don't think that they just applied those factors correctly. Factor number one is not whether or not he suffered any pain. That's not the question. The question is whether under portion 2 is whether the defendant's method or means of killing the deceased was reasonably likely to substantially increase or prolong the conscious suffering of the deceased. And the question of indifference or pleasure, which is part 1 of that test, doesn't relate to a potential person. It relates to this individual case. So let's talk about it in this individual case. The medical examiner's testimony was that a person with there's 1 fatal wound, and someone with such a fatal wound would be dead within seconds to minutes, not more than minutes, seconds to minutes. One would be hard pressed to find a smaller interval by which someone could say that the death occurred when it is recreated in retrospect. Essentially what this was a penetrative wound to the heart in which the person bled out extremely quickly. We also have testimony from the EMT, Cohen, who says, when we got there, there were no vital signs at all, and we wouldn't have changed our protocol anyway, because when you have no vital signs, the first part is just to get the vital sign back up. He did say, a stab wound that's actively bleeding, you put pressure on. But at the time when there's no vital signs, our procedure is always the same, which is to get the vital sign back. There is no evidence whatsoever that this was a prolonged and suffering death, and they don't get there by simply saying that the medical examiner talked about a potential or a possible fact that there could have been as many as minutes, and then that the defendant could have perhaps been aware of it. What we know is that at 4:45, I don't think there's any evidence that this happened outside of a 15-minute period, by the way. The mere fact that they were home and arguing, that's not the relevant thing that we're talking about as far as what led to this event. It's the escalation where it goes from an ordinary argument to a situation in which there's combat going on. And that does take place over a very short period of time based on Sophia's testimony. She says they're arguing, and then all of a sudden she hears banging, which presumably is bodies moving things around and falling. And then she hears her mother call 911. It wasn't like there's evidence that there was some laying back and waiting a period of time by Ms. Ricci such that there could have been additional suffering before she mentioned something to Christine Ricci. So the three Canine factors or the Castillo factors are whether the defendant was indifferent or took pleasure in the suffering of the deceased. Even in the light most favorable to the Commonwealth, there just isn't evidence about that. The only evidence about what happened during that 15-minute period is Ms. Ricci's statements. With regard to the nature of the injuries, the fact that having a trauma like this causes bleeding, that it causes bleeding quickly, that the bleeding is internally, none of that answers that question. Secondly, whether the defendant's method or means of killing the deceased was reasonably likely or to substantially increase or prolong the consciousness of suffering of the deceased. We just have no evidence about that. We have a single stab wound, and that was fatal, and we don't have any evidence that something was done by the defendant to prolong the suffering. Third is whether the method used by the defendant were excessive and out of proportion to what would be needed to kill a person. This is a person going above and beyond what is necessary for death. There's also no evidence of that. There's no indication that there were additional stab wounds after the first fatal one in which, there was some anger like you have in some cases. There wasn't, evidence of surrounding behavior that would suggest that something was done to the body after the fatal blow. There's none of those things. We just don't have any evidence on any three of the Castillo factors. And yes, anytime there's a death, there's going to be a trauma which causes the death, and there is going to be physical symptoms that result from that trauma. Otherwise, there wouldn't be a death. But beyond the fact that there was death here, you have essentially the story of death and nothing more. You don't have a story of someone acting extremely or atrocious, particularly as it's understood under Castillo. And it has to permit them to find it beyond a reasonable doubt. And of course, we don't have any evidence on that.
Right. In your argument, the two of you reference as is appropriate, the Latimer standard, which is drawing all reasonable inferences in favor of the Commonwealth, whether or not the issue is whether or not after drawing those reasonable inferences, it's legally sufficient to permit the jury to consider this case. And much of the argument has focused on this cruel and atrocious, extreme atrocity and cruelty argument. I'll circle back to the other arguments as well in a minute. And whether or not there's sufficient evidence before the jury in the evidence and reasonable inferences that can be drawn from that evidence to submit it to them on this theory. Although Castillo streamlined and revised the factors articulated in Canine, they did not abrogate the factors in Canine. They sort of reclassified them, put them in different categories. So in making this decision, I rely on law that precedes 2020 that does refer back to those Canine factors, which I think are equally appropriate today. I looked at these in the evening based on the fact that I knew that at some point we're going to be doing a jury charge this afternoon.
And I was really focused on the issue of, I think it's too narrow to say that the evidence supports it's a single stab wound. It's a single stab wound that kills the deceased. But the evidence before this jury is that there was another significant wound. When that happened, during the timing of that argument, is left for argument, it seems. I do not recall Sophia Ricci's testimony being so definite that the banging that she referred to in her testimony, that was part of the argument. When that happened vis-a-vis when she was called down, I don't think is before this jury. Your recollection of the evidence will control, but she heard a verbal argument that she could not hear the contents of, and there was banging also before she was called down. There are different inferences that could be drawn from that evidence and the existence of two wounds to the defendant as to what transpired. And as you know, nobody that has testified was there, and of course, nobody has an obligation to testify in any way. But there are reasonable arguments and inferences that can be drawn from the testimony that's before this jury. So I focused on the issue of a single fatal blow, even though I don't think that quite captures the evidence in the light most favorable to the Commonwealth that is here before. But both Glass, Commonwealth versus Glass 401 Mass 799 and 802 and 803, where the court found that a single stab wound where the defendant turned the knife to inflict more injury, that is distinguishable from this case, but a single stab wound. Commonwealth versus Eau Claire, which is at 444 Mass 348 at 361 to 365. Commonwealth versus Eisen 358 Mass 740 at 746. Support the idea that the case can be submitted and should be submitted to the jury on extreme atrocity and cruelty in the instances, all of them factually sensitive, of course, but in the instances where the victim was killed with a single blow. I also have looked at, and I'm going to continue to look at tonight, Commonwealth versus Doherty and its progeny, 353 Mass 197, 20, case in which a sleeping victim was roused and then shot at close range. The jury could conclude that the victim had, quote, some awareness of what was being done to him, and that therein made it proper for the instruction with regard to cruel and atrocious. I will continue to look at the cases on this, and I expect that this will be a discussion, further discussion after council's had an opportunity to look at those cases. But at the present time, my thinking is, and my ruling is, that there is sufficient evidence drawing all reasonable inferences in favor of the Commonwealth to submit this case on the second theory, that being extreme atrocity and cruelty. With regard to the other charges, both the theory of deliberate premeditation and the second charge of assault and battery as a dangerous weapon. Again, drawing those inferences entirely in favor of the Commonwealth has met out its burden to get over the hump of submitting this to the jury under Latimer as to each of the elements with regard to deliberate premeditation, and also with regard to each of the elements on assault and battery with a dangerous weapon. So at this time, defendant's motion with regard to required finding of not guilty is denied. I want to turn next to the defendant's what I'd like to have is the actual medical records in front of me and have an understanding of precisely what the defense is asking for, because it seems that to the court that There were dueling motions that we addressed some time ago. It was either at the last final pretrial conference or at the one before that, because we had a couple. And they relate to paper number 162 and paper number 166, which are dueling motions with regard to the admission of portions of privileged records and the Commonwealth's opposition to that. Whenever we last visited this issue, I told the defense that my preliminary ruling with regard to this is I did not see a path to admissibility of these records in light of the patient psychotherapist statutory privilege that's codified at Mass General Laws, Chapter 233, Section 20B, and it has a number of exceptions. I don't think that any of those exceptions apply to this case, but something that you said to me at the side of the bench caught my attention, which was that you were no longer seeking to perhaps admit all of the things that you asked. If it's some other more narrow part than in your motion, paper number 162, what is it? And I want the records in front of me so that I can be looking at them real time.
This is the more limited version.
And is this part of the last exhibit number 57?
No, this is on the Sweeney Dolly medical record that I mentioned in the motion. It would just be the diagnostic portion. Can we give a copy to the Commonwealth of the portion of the record?
Can you give it to them?
Yes.
Sure.
Yeah, I redacted. Yeah, I redacted. No, I redacted.
Okay. I see it. What's your argument?
My argument is that under section 503 as well as under 233, section 79, that's 503, section 503 of the Massachusetts Act of Evidence, which talks about psychiatric patient exception or privilege and its exceptions. Under 503, section 503, it's clear that what is covered by that privilege is communication. A diagnosis in and of itself is not a communication. It's not covered by the privilege, and it's distinct from Michael's statements, hearsay statements. Your Honor made her ruling based on Commonwealth versus McLaughlin, which were, of course, hearsay statements in that case, but not from medical record, but coming in for a self-serving purpose, meaning the defendant's out-of-court statements to come in for sort of a self-serving purpose. That's not what this is. This is a diagnostic statement written or written by a provider, a healthcare provider. We believe other statements, like for example, are for diagnosis. That's why we included them in the original motion, which is also an exception. Like the part that is essentially the Sweeney Dolly record is essentially a diagnostic document. And these are the statements that are being used to create diagnosis. So I want to preserve my objection. But obviously, the diagnosis itself is not a self-serving statement, or it's certainly not a statement taken out of context. It's just a diagnosis. And therefore, I think that comes in, particularly where the Commonwealth has
put on evidence that maybe Michael wasn't suffering from any mental illness, it was all a creation of Christine, and that Christine was the one that was diagnosing him. And the fact that we have a diagnosis of a medical provider, I think is relevant, and it is an invited response to that line of government argument. And I think the situation has changed between now and when these arguments were originally made. And I no longer think, once you wash the record of many of the statements of Michael's to the provider to get the diagnosis, I think a lot of the McLaughlin language is no longer applicable. And obviously, the 23379, from my perspective, doesn't apply to the diagnosis itself.
Your Honor, I would suggest that the situation hasn't changed at this point, even based on the state of the evidence and what came in at trial. As stated in the Commonwealth's opposition, the issue here, and Your Honor alluded to the privilege, is that 23379 doesn't make the privilege go away, and that the privilege might still override the 23379. 23379 does allow for medical record exception, but only those portions related to treatment and history, and they have to have some presumption of reliability. So the Commonwealth's contention is that these records, or even just this particular one record, that one page in a series of records that just identifies a potential for diagnosis, doesn't provide enough information or context to suggest that diagnosis was, that there was anything that supports that diagnosis provided by this particular provider. And I would suggest that based on the fact that these records are very limited, that if you look at the rest of the records that were summoned in, there is no conversation or no records or notes from the provider that identifies how that diagnosis was reached, and if she even reached that diagnosis. It could have been a diagnosis that was reported to her from previous providers. These are also records that occurred between the dates of June and September of 2019. But if Your Honor were to look at the docket in this case and see how many different records were summoned in to the court, and how many, there are even additional records that were summoned to be a grand jury for Michael Ricci. He had various treatment providers over a period of time, including other providers that provided treatment closer in time to his death that do not come to that same conclusion as far as diagnosis. And so by allowing the defendant to admit this one record, we're putting one statement without any indicia of its reliability, without any information to suggest that the clinician themselves came to this conclusion based on their contact with Michael. And we're parsing out a bigger history that ultimately isn't relevant in this case, as Your Honor had initially stated. I did cite to an unpublished case in my pleadings. I have a copy of it for counsel in the court if you would like the copy. That it involves a juvenile situation where a judge did exclude information and treatment records that did have to do with mental health, because there was not enough information to suggest the context in which that statement being offered was, there wasn't enough context for that statement, and they found it to be a more generalized notation. And I'd suggest that's what this is.
Is the defense prepared to have the provider submit to a voir dire so that the court can determine whether there is any reliability to this diagnosis?
Well, I think they're admissible. Well, I am, but I do have a problem with the provider. The provider is not in the country right now. She left a day ago, and I secured her presence at a time when I thought it was going to be plenty of time in order. I summoned her. But because we had the delay from the previous trial, it ran into a vacation, and now she's gone. But I think these come in actually under Rule 17 as well as under the Section 78 of, they came into the clerk's office with an affidavit.
How old was the defendant when he passed?
He was
Excuse
50.
me, the decedent when he passed?
He was 51.
Why does it say on the first page of this that his age is 54?
It's because of when they printed the
How
record.
am I supposed to determine that? That goes to the reliability of what's in this record.
Oh, but can we say this? That
Get her
there's
in,
a-
get somebody in there that's the record maker. Before I'm gonna even consider preliminarily whether this should be admitted, I have to know that this information is reliable. And when the date is obviously wrong on the front page, and there's no affidavit that goes with that to explain that, that makes me, just an initial, not even dealing with the legal issues, what is this document and where is this document coming from?
This is the affidavit of the record holder as well as the record itself. And what you can see is the record was printed out on 7/29/24, and based on that, he would in fact be 54 years old. I think it's
I didn't ask
reasonable-
when it was printed out. I'm looking at this document that you're asking me to put before this jury. And before I do so, I'm gonna want assurances and even consider the legal issues of whether it is or it is not included within the prohibitions of the patient psychotherapist. As you say, it is not. And by the way, I will say that I've looked at cases that indicate that that diagnosis is, but I'm happy to go back and look at that again. But as a preliminary determination, I have to have belief that what I'm putting before this jury is reliable. And when the basic information with regard to the age of the defendant, the patient, is not correct,
So Your Honor is saying that you think it's possible that maybe they got the age wrong and that the age was not updated by the computer based on the day that they
I
printed it?
don't know, counsel, that's beyond
You
my,
think the court doesn't
that's
know?
beyond my powers.
Really? Okay, well, I would say this, Your
Counsel,
Honor.
don't start
No,
with
I'm
that.
not saying anything. I would just say this. I obviously can't get the person in here because they're out of the country. I would just ask this. If I'm not able to put that in and there is a medical record that suggests that there was such a diagnosis, I'm asking that the Commonwealth be precluded in during their closing from making the argument that it was a invention of Christine Ricci. If I'm not able to put in the medical record because of the prohibitions that Your Honor has suggested and the obstacles that I cannot meet, given the fact that the keeper of records is not here and I can't do the voir dire, which would allow the
Her
court
office
to,
that can come?
no, it's just her. She's the one that actually treated Michael Ritchie. She's the keeper of records. Before she went on vacation, she brought them in with a new affidavit so that they would be properly admitted under Section 79. So
Did that affidavit address the genesis of that,
I handed up the,
diagnosis of bipolar? Was that something that she made or somebody else made that that was passed into that record? Does it address the merits?
well, it addresses, I handed up the affidavit with the package of records. Your Honor, my suggestion is that not only is it clear from, there's a bunch of statements about that they used in order to make that diagnosis. And Your Honor said you're not going to let them in. And then the Commonwealth says, well, if we just have a diagnosis without the explanation of how she got there, then that can't come in. Well, we're being kept from putting in the statements that he made that led to that diagnosis. Just the diagnosis alone? Nope, not that without her presence saying how she came to the conclusion. Fine, but I think that Your Honor should then preclude the Commonwealth from being able to make an argument about the absence of evidence with regard to bipolar disorder, since they put into evidence that my client said it. So if they want it to be the case that I'm not allowed to explore that, I'm not allowed to put it in because these records aren't reliable, they shouldn't be able to argue the negative from that.
Your Honor, may I just briefly be heard? This might be of assistance for purposes of this argument. The Commonwealth does not plan on arguing that in its closing. With that said, that should also preclude the defense from making any argument about that potential diagnosis either.
Well, I'm going to, it's in evidence, the fact that my client said that, and I'm going
Then
to,
what?
said he was bipolar. It was put in by the Commonwealth. I think I can use that fact and rely on that fact as an advocate. But if they're going to then say this was something invented by Christine, I think that's a step too far if I'm not allowed to show that it was diagnosed by a doctor.
Well, I'm not going to deal with the closing arguments right now. I'm focused on this document and the admissibility of this document. And when I rule on that, I'll give you any further rulings with regard to the limitations on the openings and closings. I'm gonna say, on the state of the records that is here before me, you know, I'm sensitive to the fact that it's the summer and people have vacation plans. But this trial has pretty much gone off to the schedule that we expected it to go. Case started when it was supposed to start, it took a long time of impanelment. That's not unusual in a case like this. And the case has gone to the 5 days of evidence, as we indicated it would. So,
Your Honor, can I make a record about that? We were supposed to start trial on the 15th of July. We did not start trial, even starting jury selection, until July 22nd. I'm not blaming the court for that, but when summonses were sent
if you knew you
out,
were gonna have a witness issue, you should have brought it to my attention. And you did know as soon as we knew that date was gonna get pushed. And there was no objections that were raised.
I knew that it was gonna get pushed as soon, but only after I knew that Your Honor was keeping that evidence out. Then
Say
things,
that again?
Your Honor had ruled on my motion preliminarily before trial started and before we knew what day it started. So I had no reason to believe, given the state of the evidence, that I was going to be able to get this in. Then we had evidence in this case that I believed opened the door to this question. That was when trial was already going on. I then made an effort to
What
try.
is the evidence that you maintain was
Your Honor,
elicited in the case? I want you to go through that again so I can consider that.
Christine Ricci said bipolar.
Through who?
Through Officer Hunt, Officer Martin. We had testimony with regard to, from Mark saying, I knew that Christine was diagnosing him with stuff. We had,
Any mention of that beyond that generalized statement by Mark?
you mean, did he mention bipolar specifically? No, he said, I knew that Christine was diagnosing him with a bunch of stuff.
Right?
And right, that specifically, he said. And this obviously, this portion of the record obviously shows that portion of it is not true. So it is, the door got opened during trial, once the trial was already underway, and I did the best I could. I contacted her lawyer, Joe Eisenstadt, spoke with him, arranged for her to bring in or to deliver to the court a new record with an affidavit, because the original Rule 17 summons didn't come in with an affidavit. She did that under our statutes. That should be, at least, that's a medical record that should be self-authenticating. So I did not expect there to be a need to do a voir dire about it, but I understand Your Honor's position. But just know this, these events occurred and they were not foreseeable. They occurred during trial, and when I tried to remedy it, the plans were already made and she was already leaving the country within a 3-day period. So I did not have the opportunity, as Your Honor suggested, to plan in advance and make sure that I had witnesses here. It would sort of be akin to the situation that the Commonwealth described when it dealt with the Michael Ricci Jr. situation when he was going on vacation, which ended up not being a problem because of the delay in the trial.
Was the information, so the two sources of information that you indicated that have come out through the trial testimony that you think opens the door to this this record being admissible, you state are through Officer Hunt and Officer Martin, that their testimony was that the defendant told them that he was bipolar?
Yeah, the statement that was taken at the scene was he's bipolar, and then one said bipolar schizophrenic, and he collapsed. That's Martin. And then Hunt says something like he was having a manic episode. That's the statement.
Manic episode is something different, and that's why I asked you specifically. And what I want to ask before, first of all, does the Commonwealth agree that that's what the evidence, that what Attorney Wood just said is the evidence? That is, that there was testimony by Officers Hunt and Martin that the defendant told them that he was bipolar. I remember schizophrenia. I remember manic.
Okay.
Repeatedly. I don't remember bipolar, but I'm not a computer.
The Commonwealth would agree with Your Honor's assessment. Officer Martin clearly testified in his report, also indicates that the statements from the defendant were that the victim, the lunch victim, was in a manic episode.
And was that information in the initial reports that were provided to the defendant?
Yes,
The manic, that's been consistent throughout.
correct.
That is the statement that has come in of the defendants through those two witnesses was that he was in a manic state for a period of 3 days before, and that he was in a manic state on the day that the stabbing occurred, right? Was that in the reports?
That was, but the statement of the other officer was that this is, we were talking about Officer Hunt now. This is what was attributed to Christine Ricci based on my notes. That's what I've been saying. He's bipolar and schizophrenic.
So now, Your Honor, we have three different, in the span of minutes, we have three different statements from the defendant about what his mental health is, and only one that's reflected in this particular record, and none of the other. So again, that questions the reliability of even the defendant's assessment of what the mental state of the victim was at the time of the incident occurred. And again, I would point to the court that the records from this particular provider are from 2019. We also have records from Pembroke Hospital, which is in September of 2020, closer in time to the time of this incident, where the diagnosis in those records that the defendant was originally trying to get in doesn't mention bipolar at all. It only mentions major depressive disorder.
With psychotic incidents, with psychosis.
Psychosis and bipolar are not the same thing. And to present that to the jury is extremely misleading without somebody to explain that information. And if I just may, before I forget this moment, because moments flee me, counsel just said that he had the provider provide new printed out records and an affidavit. Commonwealth does not have either of those things. All we have is the Rule 17 motion that was summoned into the court that we got months ago that have no affidavit with it.
That was a discussion at the sidebar when Attorney Wood was saying that these have been properly subpoenaed for trial, and I could see everybody on the other side indicating no by their verbal.
We know it came via Rule 17, but it did not have the proper medical certification page on it. And that is what we've always had. We don't have that affidavit.
But under the statute, it's supposed to go to the clerk's office. It's not supposed to go to either one of us, and it didn't go to either one of us. It went to the clerk's office under the statute, under section 79. It's to go to the clerk's office with proper certification.
And it didn't.
It did go to the clerk's office with proper certification right before trial. It doesn't need to go to the Commonwealth in order to be, that's not part of the process of summoning into the clerk's file. And when we talk about this idea of her saying manic versus bipolar disorder is two poles. One is depression and one is mania. So it's entailed, bipolar entails mania. So this idea that she wasn't hyper technical.
Psychiatric diagnoses from attorneys, all right?
No, I'm not saying that, but that is a matter of, are we saying that the only way that we can get something confirmatory in is if the words match exactly? That seems also to be a hyper-technical, limited ruling.
They're highly different things in my experience, but I wouldn't even rely on my experience. That's why we have experts. That's why we have people. I'm not taking your vermin with regard to whether mania is included in bipolar or not, or whether they're different diagnoses entirely.
My objection is not that they are the same thing. My position is that her saying the words bipolar and them are saying bipolar in one instance, and then also saying mania could be related and this part of the same thing.
And that's why it would be good to have a mental health expert to explain the significance of that. But I don't have one.
Please note my objection.
I haven't ruled on it, but I know your objection. Let me get this back to you before I lose this nice sea of papers. jury instructions, and in particular,
Can we take a break briefly to hit the bathroom before we get into jury instructions?
you may take a break.
Thank you.
To the updated model SGC jury instructions on homicide, and the date that I am using is the publication date of August 15th, 2023, which includes the updated case law from 2020. Notably Castillo. I think each of you have those instructions in front of you.
Yes.
Defense?
Yes.
Good. I think we both agree that criminal responsibility is out and joint venture is out. I think you further agree that defense of another is out. I'm just going to those areas where I think we have agreement. I'm looking for you to tell me if I've got it wrong. You agree with regard to felony murder out. You agree that voluntary manslaughter, absent murder charge is out. You agree that charging of a minor with murder is out. You agree that it is too soon for any questions to the jury before questions from the jury, both of those are out.
That is instruction that would be given before supplemental instruction and after supplemental instruction. And you agree that the instruction regarding after jury reports deadlock on murder in the first degree is inappropriate. And I agree with all of those things. That is, I think that that agreement is appropriate. Any other things you agree upon that I didn't list?
I think we agree on voluntary manslaughter as an independent instruction.
Do you agree on that?
No, the Commonwealth is asking that it be just the lesser included.
All right, we'll get to that. So let's talk about the disagreements. First, we disagree with regard to the propriety of the self-defense instruction. And defense believes it should be in, and the Commonwealth does not. I'll hear first from the defense.
The evidence in this case involves of what happened at the time of the death, involved mostly the statements of, it involves the testimony of Sophia that mom sounded panicked, mom was shaky, crying, trouble breathing when she came down and hyperventilating. During fights, dad acted aggravated / frustrated, including when he couldn't remember things about the affair. Mentioned the stuff about the differences in that Christine had a joint condition, often wore an arm brace, that the mother was, that Michael was more agitated once he started drinking and would raise his voice and all of a sudden get angry. There's a text message to Angel, which they introduced as exhibit number 4 with the words, "He was attacking me." There was testimony from Angel that that Christine had arthritis before the affair, wore a brace on the arm. Christine wore a brace a lot, could stop her from doing certain things. Left hand, it's on her left hand, even though she's right-handed. According to the testimony, dad was significantly taller than mom. The testimony of Chris Martin was that Christine Ricci was frantic, hyperventilating, yelling and screaming. Christine said to him, manic episode, suddenly collapsed, couldn't understand some parts. When talked to Christine again, she says there was an argument. She feared that he was having a manic episode, so she grabbed a knife. Christine said that she was scared. Michael lunged at her. From Hunt, we have Christine say she took a knife to defend herself. And from Hunt, we have Christine say that Michael lunged at her. We have from Katrina the height differential. That's the evidentiary basis. Now, the law is that the evidentiary threshold for a defendant seeking instruction on self-defense is low. That's the Commonwealth versus Ortega on page at 480, Mass 603, on page 610. In determining whether evidence warrants an instruction of self-defense, we consider the evidence from any source and resolve all reasonable inferences in favor of the defendant. When deadly force is used, such as in this case, a defendant is entitled to instruction on self-defense where there's evidence permitting at least a reasonable doubt that the defendant reasonably and actually believed that that the defendant was in imminent danger of death or serious bodily harm. That the defendant availed themselves of all proper means to avoid physical combat before resorting to the use of deadly force, and that he used no more force than was reasonably necessary in light of the circumstances. Here we have very little evidence about some of that information, at least the second two prongs. However, we do have all of this evidence with regard to the physical incapacity of the defendant, the much larger stature of Michael. I know Your Honor mentioned of the situation of deadly force, and when deadly force is first initiated, it's a little bit different in a homicide case than in other kinds of cases because you're dealing with deadly force. I would suggest that even though there is case law that suggests that the moment that a person pulls a weapon is a moment of first aggression, that's not the case here. The testimony seems to be that, as I mentioned a moment ago, that essentially there was a knife pulled by her own statements to ward off Michael Ricci. In other words, he was manic, and she felt scared, and she grabbed a knife to ward him off, which wouldn't be the initiation of deadly force at that point.
What wouldn't be the initiation? of
But
deadly
pulling out of the knife, if it
force?
was
Is that
being,
consistent with the law?
yes.
Counsel?
Well, I think it's consistent with the law if we make a distinction between the situation in which a person pulls out a knife with the intention of using deadly force at that moment, whereas a person pulls out a knife for the purposes of warding someone off so that they don't get into a conflict. That would be an example in which they weren't attempting to use deadly force. I think the evidence in this case is that the moment of deadly force happens later, after this moment of lunging or maybe falling in a struggle that occurs at that time. So we don't have a situation like in some cases where a person goes and grabs a weapon and is intent to initiate the process of deadly force on their own as the first aggressor. We have a person who grabs a weapon with the intention, at least based on the statements, and in the light most favorable to the defendant, to ward off, which is non-deadly force. And then something happens which escalates somewhere along the way. And
Even if I credit the defendant's own statement that he was manic and I was scared and I took the knife because I was scared. That's her statement to the police, is reported, and now has been reported twice to the jury through two separate incidents. That is frankly the only evidence this jury has right now of direct evidence of an account of what happened during that encounter between the defendant and the decedent.
Your Honor, there's also the text. I just want to remind you, the text Angel, he was attacking him. But attaching, but then it was corrected through testimony as being likely meant to be attacking.
So the two issues that I pointed you to Chambers, and Chambers really deals with the issue of in the context of homicide, and I'm reading from that case, as I told you yesterday. In the context of homicide, in terms of the definition of first aggressor, defendant may lose the right to claim self-defense only if he was the first to use or threaten deadly force. So your argument is in part viewing the evidence in the light most favorable to the defendant, largely based on that text.
Based on the text, plus the statements, everything together.
Well,
plus
your
the-
statements alone doesn't help you, I don't think,
Plus
because
the resistance.
the statement alone doesn't help you because under the case law, it indicates that things such as throwing a punch, verbal altercations, and other acts to include instances of individuals being excited none of those things rise to the level of the first use of threatened or deadly force. So what she says to the police has been reported is not enough, I don't think, to entitle you to the self-defense instruction. I will go back and look at that text message, and I know the Commonwealth's going to say, well, that was just created after the fact, but I have to view that in the light most favorable to the defendant in terms of whether she's entitled to that instruction. But it seems to me, based on her own version reported to the police of what happened, she falls squarely within the prohibition of the Chambers as to what is and is not permissible in terms of her claim to self-defense.
Could I say one thing?
Yes. And then
Taking out a knife in and of itself also is not a per se first aggressor deadly force situation.
isn't that what Chambers said?
No.
The critical question here in determining whether the Commonwealth has proved that the defendant did not act in self-defense when he killed the victim was who first grabbed the kitchen knife that ultimately was the instrument of death, not who shouted first or who struck the first punch, because it was the grabbing of the knife was the act that transformed a relatively harmless fight among roommates into a deadly one. Why doesn't that equally apply to this case?
Well, it's in that particular scenario in which people are just yelling at one another, somebody grabbing a knife with the intention of using deadly force, the grabbing of the knife is the beginning of that process, but that's not what's happening here. If you take the two statements together, the statements made to the police with the statement, he was attacking me, you have something that suggests that he was, plus you have a scenario in which there is a suggestion that this act of deadly force occurs while the attacking is going on. And that it may be the case that a knife is pulled at an earlier point when you take into account also all the evidence that's been put on with regard to suicide. There may be another reason why she pulls a knife out that doesn't have anything to do initially with Michael Sr., but it might become about Michael Sr. after there is this attacking, which is described in the text to Angel.
I hear your argument. I want to talk about,
Sorry, can the Commonwealth offer some cases that might shed light on the questions your honor is posed to counsel?
yes,
So this idea that the defendant loses her right to claim self-defense when you're the first to introduce deadly force isn't new to Chambers. It's the common law principle, and it requires that in order for the defendant to be entitled to self-defense, there has to be, the defendant must raise reasonable doubt that there was a reasonable ground to believe and actually did believe that she was in imminent danger of death or serious bodily harm, for which she could only save herself by using deadly force. And I suggest that the distinction there is it has to be reasonable and that they actually did. The fact is, this defendant went and armed herself with a knife before she even did anything. She tells the police that I went to go grab the knife to scare him. She does make a statement that she was scared, but I suggest that her statement that she was scared isn't enough. In Commonwealth versus Reed, it's an SJC case from 1998, 427 Mass 100 is the site from 1998. It says that even though the defendant in that case testified that he became scared immediately before the stabbing, there was no other interaction that raised that level to a means in which deadly force would have been the applicable or the correct action or would have entitled them to self-defense. She went to the kitchen, she got her knife, she said that she was scared, she told the police she grabbed it to scare him. She didn't tell the police she grabbed it to protect herself. She said it was to scare him. And then she continued to identify that she used it and created the idea that he first lunged at her when she used it. There is consistent case law. I have Commonwealth versus Gonzalez with a Z, 465 Mass 672. It's an SGC case from 2013 that involved the stabbing, where the defendant in that case told police immediately after the incident that he was defending himself from a group of individuals who were trying to jump him and kill him. And in that case, the SJC said the fact that he made that broad statement about defending self without any specific actions as to what he was defending from wasn't enough to give him the entitlement to the self-defense instruction. That there was no specifics to suggest or infer that the victim in that case was actively participating in the jumping of the defendant or of the threat to his life, and therefore he's not entitled to that defense. And I suggest similarly in this case, there is nothing before the court, even based on her own statements, to suggest that the victim did anything to make her actually believe that she was in fear of imminent bodily harm or death. The other thing that, so the two other things that the defendant, that needs to be considered when the defendant is asking for self-defense, and again, this goes back to common law, Commonwealth versus Harris, is an SGC case from 1978,
The second thing is that the defendant has to avail themselves of all proper means to avoid physical contact. And we haven't talked about that yet,
Gotta get to that next.
but there is some testimony before the court. There's plenty of testimony before the court that the victim fell in the area between the dining room and the living room. There's been some suggestion, I would say, through questions of counsel, that maybe something happened in the kitchen and that the victim's body was closer to the kitchen than in the dining room. But we do know that from that kitchen, there's two ways to exit. There's through the dining room, through the living room, to the out the side door, which everyone testified is generally where people went when they kind of left the house, where Michael went when he smoked his cigarettes. And there's also a front door. And the kitchen is accessible to both means of egress. And in this circumstance, there's no evidence before the court to suggest that she did anything to avail herself of the situation, even before she picked up the knife. But even after she picked up the knife, there's no evidence to suggest that she did everything she could to avoid physical combat. And in fact, the prior bad act suggests that she never shied away from it. She never shied away from the physical combat when it came to these arguments. And she was the one who often escalated these arguments to physical combat. And the last thing is that the defendant used no more force than reasonably necessary under the circumstances. Again, there has been plenty of testimony before the court that the defendant had used physical force against the victim in the past, that she punched him, that she gave him injuries, that she even harmed herself in doing so. And so to suggest that her only source in this instance, even if you were to find that her statements that he was manic and that she was scared because of his behavior were enough, which I don't think they are, even if the court were to find that, it didn't mean that she had to pick up a knife, because she had diffused situations many, many times in the past by physically striking him with her fist, or however she hit him to cause him to have black eyes, broken nose, and bloody lip. So I suggest that those are all circumstances which suggest that she's not entitled to the self-defense. There was one more case that I wanted to cite to the court. It is an appeals court case. It's Commonwealth versus Christensen. And that is it's an unpublished case from 2017, where, and the unpublished site is 91 Mass App Court 1124. But that is a case in which the victim and the defendant actually agreed and made plans to engage in a fist fight. They had an argument over the phone. They engaged in this plan to meet up and settle it with fists. And that the defendant then went home. There's evidence in that case. The defendant went home, got a knife, and brought a knife to this fist fight that they agreed upon having. And in that case, the appeals court said because the defendant brought the deadly weapon to the fight, he's not entitled to self-defense. And again, in this situation, she brought the deadly weapon to an argument. For all intents and purposes, that's all these ever were arguments. It never resulted in a physical contact with a deadly weapon before today. And this was an argument. And she brought the knife, and she shouldn't be entitled to the instruction.
You want to address defense's requirement that in order to raise the issue of self-defense, there has to be sufficient evidence that she attempted to extricate herself or took all reasonable steps to retreat from the conflict.
Well, all there needs to be is any reasonable doubt from the light most favorable to the defense. When taking the evidence, the light most favorable to the defense. If we take the statement to Angel to mean he was attacking me in the context of presumably meaning that the stabbing occurred while he was attacking me, then the attacking would have already been happening at the time of that deadly force being used. That's in the light most favorable to the defendant. Now, of course, we can write different stories in which she does not have that, but that seems to me to be a question for the jury. The case that was just cited about a guy leaving the scene of a fight, going home, getting a knife and bringing it back seems to be completely different than this case in almost every respect. But what is clear is that.
So are you agreeing? You're saying under the circumstances of this case, the paucity of any evidence that she took any steps to avail herself of retreating from the conflict. Basically shouldn't apply because she was already under attack.
She was under attack, which implies that she was being attacked at the time that it happened. And in light most favorable to the defendant, what that means is that at that point she couldn't retreat. And, or at least there could be a reasonable doubt as to that, which is the question. It's not, whether or not you accept the judge or you think it's
Like
likely.
most favorable to the defendant.
The light most favorable to the defendant for the question of self-defense came from the, was it the Ortega case that I quoted to you just a moment ago at 480 Mass 603, the evidentiary threshold for a defendant seeking instruction on self-defense is lower. We begin in determining whether evidence warrants instruction on self-defense. We consider the evidence from any source and resolve all reasonable inferences in favor of the defendant.
But when there's conflicting evidence, then the court can take that into consideration as well. And so I suggest reasonableness of it, the court can take into consideration. And she got the knife before she's alleging that he lunged at her.
She tells Hunt she took a knife to defend
The
herself.
only evidence on the record right now of any burn of acts by the decedent is that text message to Angel. Where's the text message in Angel?
Exhibit 4. Do you want a black and white copy?
This is the email I sent at 5:41.
Yes, Your Honor. Could I also mention the Galvin case, which says that whether the evidence raises a reasonable doubt as to whether predicates for self-defense is often a complex determination that a trial judge should, quote, err on the side of caution in determining that self-defense has been raised sufficiently to warrant instruction. And that's the Galvin case at 701, quoting Commonwealth versus
What's the
Toomey.
sign to me?
It's 56 Massachusetts Court at, and the internal quote is 701. It's, I think, it's Galvin is 56 Mass Appeals Court 698, and that's the pin code is at 701.
All right, I'll take a look at that.
And also Ortega, which is 480 Mass 603, which I mentioned earlier. There's also Commonwealth versus, I want to make sure that I get this name right, Iacoviello, Iacoviello, at 90 Mass Apport, 231, it's a 2016 case as well, which deals with the same issue of erring on that caution and giving instruction.
Take a look at that.
Not the Ortega citation again, please.
480 Mass 603. We've talked about the alternate theory a little bit in connection connection with the required finding and not guilty, but I'll hear any additional information. Kamala's seeking that instruction. I'll hear from you first.
I would just rely on all the arguments that I previously made in support of the motion for denial of the required finding.
Same arguments.
Um, I'll hear from you with regard to the disagreement on voluntary manslaughter.
I think we also agree that it's the lesser included voluntary manslaughter, so I think we do agree.
Second degree voluntary.
So the only, I guess, disagreement in that would be in talking about the mitigations and whether excessive use of force in self-defense would then be applicable. The Commonwealth's position is if Your Honors finds that she's not entitled to self-defense as part of the more general instruction as to first degree, then therefore she wouldn't be entitled to it. And there's cases, some of the cases I've already cited actually discuss that same principle, that if you're not entitled in one instance, then you're not entitled in the next, for excessive use of force in self-defense. So that would be the only disagreement I would say as to that lesser included voluntary manslaughter that wasn't particularly, I didn't identify that in our proposed jury instructions.
What's the, I'll look through what you have, but what's the case that is the easiest one for me to look at that stands for that proposition that if self-defense is out, so too, it's prong 3 of the mitigating factors.
If I could just have one moment.
Sure.
Appeals Court 1, I think some of the cases I've already cited do say the same. I just can't place my hand on the exact citation, but I know another case that's an appeals court case, Commonwealth versus Toon, Toon. It's 55 Mass Appellate Court, 642. It talks about, it's basically the second paragraph of the actual opinion where it says, we conclude the defendant was not entitled to self-defense instruction at all, and therefore is not entitled to an instruction on the use of excessive force in self-defense. In that instance, it had to do with the voluntary manslaughter.
First, as an initial question to defense, do you agree, and I'm not pre-ruling on anything, but if the self-defense instruction is out, do you agree that A3 is out of the instructions on voluntary manslaughter?
I think that's a correct statement of the law, but can I have a moment to?
You can have until more than a
Tomorrow.
moment. You can have till tomorrow. Let me know. I can always put that in.
I also found it, I'm sorry, Rodriguez is the SJC case from 2011. It also says that.
Decide on that, not a question.
It is 461 Mass 100, and it's at 109. It's a subheading that talks specifically about excessive use of force in self-defense. Before a judge may give such an instruction, the defendant must be entitled to act in self-defense. Thank you for indulging me.
Thanks for getting this right. The next point of disagreement is about the involuntary manslaughter, lesser included offense. The defense is seeking the instruction on involuntary manslaughter. Commonwealth has indicated that it doesn't think it's appropriate. Is that correct?
That's correct, Your Honor. The Commonwealth's position is just that the facts don't warrant involuntary manslaughter. Also, I find that when we provide the jury with some of those instructions that can be convoluted and confusing, it dilutes the issues before the jury, and basically the facts in this case don't support involuntary.
Well, is that right? I mean, distinction that's made with regard to the proof of malice, as is required for all of the homicide charges, and the idea of what's associated with an intentional act, versus the recklessness that is found in the involuntary manslaughter. Isn't it the case that if this jury reached determination that there wasn't sufficient evidence of malice, that a version of the events that would be believable, perhaps beyond a reasonable doubt, reasonably beyond a reasonable doubt, is that she held out the knife in a reckless and blunt fashion, and death resulted. Their theory of the case is that the knife is out. She said to the police officers he either tripped and fell into it or plunged himself at her, and that was what happened. If it's credited by the jury, isn't that by its nature that reckless?
Possibly if you take that action alone, but we know there's a second wound that's on his back.
That one's hard to explain, but that's not the fatal wound, right?
It's,
I take it that the medical examiner testified today that it was a combination of the wound. She said the wound, she didn't my say the wound number one. That is the wound that struck the heart.
right, so my recollection is her testimony was obviously more extensive as to wound one, as to what the internal injuries were, that would have led to the circumstances where he, lost half his volume of his blood and all of that, and I don't think, I think she identified that there were two stab wounds and one incisive wound. But again, I think that
Isn't that argument though for you to be making? I mean, it seems like if you credit what the jury can credit and they can choose not to. They may, I'm sure, you asked for the consciousness of guilt instruction. I'm sure a big component of your argument is with regard to those statements shouldn't be credited at all because they were only brought to the attention after she was made aware of the fact that they'd uncovered the stab. But within their province to say that they believe it. They believe it. And the way that she describes it is that she was afraid. She took out a knife. She was scared. She took out a knife to scare him in response. And he somehow fell or lunged at her, thereby causing the deathly injury. Isn't that squarely in what the involuntary manslaughter charge encompasses?
I think it's a fair statement to be that it's the argument to be made. Obviously, that is the Commonwealth's argument to be made, that it's not that situation.
No, your argument is this was malice, that she intended to do this, intended to kill him. That's your argument. But a reasonable, it seems, alternate to that argument is what I just recited, and I won't recite it again. And that, to me, seems to squarely fall within the confines of non-malicious conduct that resulted in his death through reckless conduct. I'm not ruling on it. I'm just telling you, like I did with the other issues, sort of what my preliminary research on the law led me to. Think about that. I didn't mean to cut off your argument with regard to my musings. Go right ahead.
I don't need to put too much on. I think that is my position, that it could be parsed in that way. I would just point out the case of Commonwealth versus Tavares.
I have it, yeah.
Oh, okay.
Put it on the record.
And that same Iachiavello case, that 90 Mass Act Court 231, particularly the facts as it relates to what they said went on in that case, in the part which describes the involuntary manslaughter portion under the B section of the analysis on page 1044 of that decision. I'm sorry, that's the wrong citation, 245 of that, in that form citation. And
what was
the
the second
Tavares
one?
case is 471 Mass 430.
So it's specific to Tavares and specific to this case. Tavares is a little different. I was a little disappointed. I read a parenthetical about it. I thought, oh, this is the answer to this question. And I got to Tavares and wasn't so great because it really has to do with the impropriety of the prosecutor's argument. And the impropriety that was alleged was that prosecutors made the statement that simply by taking the gun out and pointing it in the direction of the decedent, that was malice. And the court in Tavares says that's not enough. That such a suggestion, when not combined with other factors that support an inference, is improper. Because although we've said that malice can be inferred by the act of shooting somebody, we've not adopted the same inference merely by pulling out the gun and pointing the gun. And then they went on to say that thus the prosecutor's reference that was malice in and of itself was wrong. But inferentially in there, in replacing gun with a knife, you can get to propriety of a involuntary manslaughter charge on the evidence, the limited evidence that we have here, which is that she took the knife out because she was afraid.
So, Your Honor, with regard to Tavares, I would point out that on page 437 of that opinion, it does say that the facts in Tavares would warrant an involuntary manslaughter instruction, not just simply that it was
Right.
wrong for them to argue this issue of malice as a result of pulling the gun out. I would also point out the fact that in this case, they make the distinction that I made before during my argument, this notion that the reason for pulling the weapon is important in determining whether or not this was with the intention of acting in deadly force or simply do something short of that, like scare or ward off.
All right. If I do give the instruction, I'm not giving any pre-ruling on that, but if I do give the instruction on involuntary manslaughter, it seems to me that both A and B are then appropriate. Let me look at 70.
Well, I think A.
Let me look at 70.
I think A for sure. I'm not sure that this was in the context of a non-felonious matter. So I'm not sure if B applies, but I think A does.
Yeah. All right, minors out. I'll hear from the defendant on the use of a dangerous weapon. Exclusion. on page, on my version is 73.
So just have a general problem, I think, giving in this circumstance creates a burden problem.
Why?
Well, because it talks about essentially their ability to infer simply through the dangerous weapon alone, something about the intentions of the defendant. I think in this case where, they're having to make this determination about malice aforethought, that amount of information, just the fact that she had a dangerous weapon, particularly where the manner of its use doesn't necessarily support it in this case, because again, the testimony is something about scaring and warding off, as opposed to getting out a dangerous weapon with the intention of using it to kill someone. At least that's an open question. It's not agreed that when at the moment
Is that what the instruction says? You're permitted, but you don't have to?
where the judge determines from the evidence at trial that the nature of the dangerous weapon used and the manner of its use reasonably supports the following inference. And so what we have here is we have very few statements made by the defendant, and we don't have information about the manner of its use at the moment it was taken out. So I don't think there's given that portion of the instruction that determination has to be made. I don't think the court has enough information to make that determination, that simply by the grabbing of the knife in this scenario, that there should be some inference about what was going on in Christine Ricci's mind.
All right. Well,
I think the instruction actually reads, counsel's quoting the kind of direction to your honor about whether to offer it, but the instruction itself reads, as a general rule, you are permitted but not required to infer. So I think that the jury isn't calling upon the jury that they have to consider it. They're not required to. And that this is a knife and it's used in a particular manner and that it's an inherently dangerous weapon. And so it's appropriate to give the charge.
give some thought about it. The jury's obligation on guilt or innocent, the defense wants to have instruction out, Commonwealth wants it in, I'll give them the defense. It's one that basically said, is the evidence convinces you beyond a reasonable doubt that the defendant is guilty of a criminal offense, you have a duty to find the defendant guilty of the most serious offense that the Commonwealth has proved beyond a reasonable doubt. If the evidence does not prove beyond a reasonable doubt that the defendant is guilty of any offense charged, you must find her not guilty.
So it's clear from the rest of the charge that they have a duty to find these facts, and if they do, they're required to. But so this is just unnecessary in the circumstances. Or to find them guilty of each charge before they move on to the next charge. So I think it's already entailed within the instruction in a number of other places. And this is sort of, from my perspective, just more language that is potentially creating sort of like this urging that they should, I just don't think it's necessary in this case. And I think that there's more chance that it would be used to sort of frame the idea that they should consider especially the most serious offenses that the Commonwealth has brought. And to put this in addition to the rest of them, I think gives too much emphasis to that idea, which is already contained in the instruction in a number of other places.
Your Honor, based on the fact that Your Honor is inclined to give a series of different instructions, again, these are lengthy instructions, each one of them, but this is simply just a reminder of what their obligation is under the law. And the footnote in the instructions cites to it that the jury is required by law to return a verdict in the highest degree. So where the court's instruction provides them with a lot of different alternatives, these are lay people that don't have, prior knowledge of the law. You're teaching them the law as we go. But I think this is just a reminder that that's what their obligation is in light of the fact that they're given so many different options.
Any other areas of the homicide instruction that we need to address? Hearing nothing, I'll take that as a no. So next, the instruction on intentional assault and battery with a dangerous weapon. I think the version printed out the Superior Court instructions. Can't find it right now, but I did print it out. Have you reviewed those instructions on assault, battery, dangerous weapon? For the life of me, I can't find the instruction right now, but I'm sure I'll find it the minute I step off the bench. Here it is. Have you looked at that instruction, and have you reached any areas of disagreement?
Our position as stated in the email to the court was that we think it's appropriate minus all of the supplements because they're not appropriate. But we'd also request self-defense in the context of ABDW, and I understand that that's derivative of your probably ruling with regard to self-defense more broadly.
Running on this?
So just I guess initially our thought was the intentional assault and battery dangerous weapon that's in this would be fine. The only caveat, I guess, if the court is inclined to instruct on involuntary manslaughter, then we would ask that both the intentional and the reckless theories be offered to the jury in light of the involuntary instruction, just so that the law appears consistent. As far as the self-defense, I would agree if the court is not inclined to allow self-defense in the murder, then it's not applicable in the assault, battery, dangerous weapon, again, because we're talking about an issue of first aggressor, and if the defendant is alleged as the first aggressor because of her actions, which is not entitled to the instruction, and anything otherwise would confuse the jury.
Any disagreement with regard to the reckless?
But I do point out that there could be scenarios in which someone could be entitled to use non-deadly force in an ABDW and not in murder. So they don't necessarily fall together completely, but I understand the point with regard to first aggressor.
All right. Anything else that we need to cover?
The supplemental instructions, including
Yeah.
active.
So, the Commonwealth. I had a list on my desk, but I didn't bring it out here of the pending, requests for, supplemental instructions. I know the Commonwealth indicated, them. Can you just recite them again to me? I don't know how sticky.
Yes, Your Honor, as far as the Commonwealth's, we're obviously asking for you to give the other bad acts instruction consistent with the instruction you've been giving contemporaneous testimony. We're asking for the consciousness of guilt instruction, based on intentional false statements. I think the use of the dangerous weapon is also listed in our pleading, but obviously that, if the court is giving it in connection with the murder, it's simply a reminder that they've previously been instructed on it. It's not its own separate. We're also asking for the rehabilitation instruction for prior consistent statements and the expert witness instruction.
That's what supplemental are you looking for?
Defendant doesn't testify, other bad acts, photos with impact, with emotional impact, that's 3.920. Accident at 9.100, and mental impairment short of insanity, 9.220.
Can you go back a little more slowly?
I'm sorry. Defendant doesn't testify at 3.600.
Photos?
Other bad acts, which I think we agree on. Photos with emotional impact, 3.920. Accident.
Where's that at?
9.100. And mental impairment short of insanity at 9.220.
Anybody want prior inconsistent statement?
Can we reconfirm tomorrow?
Yes. Figure I'd start with the low-hanging fruits. Does the defense object to any of the Commonwealth's supplementals?
Consciousness of guilt?
Okay, do you want to be heard on that?
Yes, Your Honor. The evidence in this case was that, let me make sure I get it right. The evidence is insufficient to warrant it in this case. The Commonwealth suggests this is appropriate based on supposedly false statements made by Christine. One, no false statements made. They must be intentionally giving false statements to the police in order for it to constitute consciousness of guilt. And the text and the context makes it clear that that's not what happened here. Officer Martin, testimony is Officer Martin arrives on the scene. He's the one who gets the first conversation with Christine. During that conversation, she is emotional, she's crying, she's heaving, she's hyperventilating. He cannot hear everything that she's saying or understand it. What he takes from that veil of words that are thrown at him, it is the words manic episode and collapse. From that, I don't think it's possible. I'm not saying they can't argue, but as far as instructing that that's consciousness of guilt, that this is an intentional statement, I don't think that there's an evidentiary basis for that.
That's not what the instructions said, right?
Well, the instructions
Just
suggest
say
that.
if you find that she provided a false statement, you must find that that's evidence of consciousness of guilt. You may. You may.
Intentionally.
I got the intentional part.
Right.
The
And there's no-
instruction doesn't say what you're saying it says.
Well, it says that in order for it to be a consciousness of guilt statement, it needs to be an intentionally false statement.
Right.
I don't know that there's evidence that it's a false statement, number one, because again, the report of Chris Martin about the first statement that was made is not that she only said manic episode and collapsed. It was, that's all I was able to take from the words that were thrown at me. And secondly, that it was intentionally false is also unclear given the state of the evidence.
Is that a reasonable inference from the, that can be drawn from the if credited, the testimony of at least 2 law enforcement officers in combination with the EMTs and fire personnel that, however imperfectly delivered in her emotional state, that she said nothing about the stabbing until after the stabbing was brought to her attention.
I don't think so. My memory of the evidence, and I go to Your Honor's memory that is going to prevail in this instance, but my memory is the EMTs were all working on the body. They weren't in charge of talking to Ms. Ricci. Essentially, they say, all we heard was, and then they say the bit about collapsing. There's every one of the law enforcement officers who testified, both Hunt and Martin, both said they can't be sure if that's all that Christine Ricci said during the time that.
But all they
Martin-
remembered was that she said, right? All they remembered is that she said he collapsed.
That's all that they could get. That's all that they could hear of what she said.
Right. And you're permitted to argue that she was in this hysterical state and they could, maybe they didn't hear what she had to say.
Well,
But the timeline with regard to the revelation by the defendant of the knife is after she is confronted, right? After the fire chief comes out of the ambulance and they return to confront her and say, hey.
that's all. No, well,
So,
no, I don't think that's the state of the evidence. I think the state of the evidence is there was a conversation with Christopher Martin in which he could not understand everything that was being said. He heard collapse and he heard manic episode.
Mhm.
I think no EMTs were able to put any more content into the statement attributed to Christine from Chris Martin. And then there is the statement that the first time they heard it clearly about the stab wound and the knife, according to Officer Hunt, was the statement, that's what I've been telling you. He was having a manic episode, or whatever that statement was, that second statement. And that second statement is presumably the one that they want to be the more fulsome statement, and the first one is the one that they want to be the intentionally false statement. And what must be clear, I think, is that it must be, if the issue is the fact that she didn't mention the stab wound is a lie because she omitted that, then the adoptive admission that they're, by silence, which is what they're trying to do here, must be apparently heard by the party making the statement, and it must be understood. So it must be apparent the party heard the statement, and the statement must be understood, and the defendant must have had an opportunity to respond, and the context was one in which the party would have be expected to respond. And I don't think those are met. Martin didn't fully understand everything that Ms. Ricci was saying. It's not clear that Ms. Ricci, in her emotional state while Martin was talking to her, fully understood what the question was, or had the opportunity to respond. And context was not one in which she would be expected to give a complete statement of events, given the fact that these officers are actively working on trying to revive her husband who's on the ground, and she's watching that happen, and she's saying through her blubbering emotions, and she may have mentioned the blade as is suggested by the statement that Hunt suggests, but even if she didn't, the context in which that silence is being treated as an admission is not sufficient given the necessary requirements of the evidentiary rule. So under Rule 303 of the Mass Guide to Evidence and the Nickerson case, the pre-arrest silence to show consciousness of guilt and indicating such evidence is admissible is only in unusual circumstances where apparent that the party heard the question and the statement was understood, meaning the statement that was required, and meaning the statement that's being responded to was understood, and the context was one in which she would have, under the circumstances, have been expected to respond. And for that, I point to the Commonwealth versus Gardner, 479 Mass 764, 2018 case.
what's the page say?
479 Mass 764. And obviously, under the Nyland case, even if it is given, it can't be considered on malice aforethought.
So, Your Honor, as far as whether it was clearly communicated to her what she was being asked, they arrived and asked her what happened. And she said, he suddenly collapsed. Yes, she was hysterical, but there was testimony from Officer Hunt that when they arrived, she was hysterical, but they were able to get that from her. They clearly didn't hear anything else, because if they did hear anything related to whether he was stabbed, that would have informed how they treated the patient. None of them, all of them were surprised when they saw the blood on the paramedic's hands. And I'd suggest that Officer Hunt further testified, when asked a little bit further about what she was saying, he said not only that he didn't hear her say anything, but that she was just yelling and screaming, and it didn't sound like she was saying anything. She was just yelling and screaming, but they weren't really words to put together. So to suggest that she was trying to tell them and didn't because of her state, I don't think is accurate. And I think that the statement is that when she was asked specifically what happened, she said that he suddenly collapsed, which is not the circumstance. He didn't suddenly collapse. A knife was inserted into his chest, and then he collapsed. So I would suggest that it is an intentionally false statement, and that's the instruction.
I don't believe that the state of the evidence is that she said he suddenly collapsed.
And furthermore, we not only have the first responders, we have her first interaction with Sophia. Sophia comes downstairs, and the defendant doesn't tell her anything about what happened, other just been calling 911. And in the 911, Sophia is asked specific questions about what's going on, and she said she doesn't know what happened, meaning the defendant didn't tell her. So again, that is indicative of the fact that she wasn't volunteering the information, and then when she was further asked specifically for the information, she didn't give it.
You can't have an admission by silence if no one asks you. So the testimony of Sophia is that she was told to call 911. She came down, saw her father on the ground, and didn't ask her mother any questions because her mind was occupied with trying to get her dad help and talking to the 911 operator. And then she went up, she saw her mother was upset. She gave her medication and then went outside to wait for first responders and police to arrive. So the fact that under the circumstances, there wasn't information volunteered, which is, I guess, the argument, that's not an admission through omission. And therefore can't be the type of thing that we consider when we consider consciousness of guilt, which is either an intentional statement or an omission or a failure to make a statement when one would be expected.
Right? Any other objections to the comments? Supplemental instructions?
No, Your Honor.
With regard to the defense's supplemental instructions, what does the Commonwealth have to say?
At this time, Your Honor, I would object to the mental impairment short of insanity, but to be honest with the court, my focus last night was on the broader issues that Your Honor mentioned to us. So if I could just maybe have a chance to look at the case law cited in that instruction and do a quick search to see if I can find anything else. My gut reaction is to just say that I don't know that just descriptions of her demeanor at the time, the yelling and screaming, hyperventilating, is enough to qualify as mental condition. But I would like the opportunity to just look a little further.
All right. Any others?
No.
Oh, I don't have any.
We had drafted an instruction with regard to, and showed it to council before we gave it to Your Honor, because we thought there might be an agreement with regard to it. And it is the defendant's request for instruction regarding search warrants. And pass it up.
We may. All right, anything else with regard to the jury instructions that anybody wants to raise with me at this time?
Not this time, Your Honor, thank you.
No.
So at some point tonight, you're gonna get a draft set of jury instructions. If the instruction is in regular print, it's in. If it is in italics, I'm thinking about it. Now, to rule on it, we'll take the rest of the night. I want to get you sort of the basic parameter of what is the most universe, so to speak, of what will be in the instructions. And to the extent that I've heard your arguments and made decisions with regard to those instructions, you will see that reflected in the fact that it is in regular print. If it's in italics, it means that I'm thinking about it, but I want it in there in the event that it's easier to remove than it is to put back in on the morning of the trial. Probably in light of the hour, I'm only going to get you one draft. I'm not going to send you a draft at 11 o'clock. Probably send you a draft 7 or 7:30, and then I'm going to think some more about the issues that I need to think about to get just to a place where I'm comfortable with the record's been established by both sides for what, and given the limitations of time, that I've done what I can to reach final decisions on those. I expect to see you all here back at 8:30 in the morning, ready to address any additional concerns that I have at that time, or additional argument that I need at that time.
Did you say 8:30?
8:30. I will also tell defense counsel that it's my practice in every case to conduct a colloquy with the defendant. I'll do that in the morning, and I know that you've asked for the instruction. If she chooses not to testify, I will